2 times left over.
What kind of thing?
Zimma petition of vehicle.
Court number 11. Make a mention before court number 11.
Need please, my lord. Item number 48, my lord. Last time 2 times listed, but matter was not raised, my lord. So kindly update the matter, my lord, after motion item, my lord.
What in what column it is? 48.
48, item number 48, IA case.
In order column.
Order.
Order column will come after bail hearing and all only.
Dear, my lord,
Admission.
two time listed matter was listed.
We'll try at 2
But
we'll try.
item 48, it is not possible for reach, my lord. If I am waiting, my lord. He suffer, my
Now
lord.
see what to do. There are lots of matters. What
Yes,
to do.
I know, my lord. Kindly matter already.
We'll try. We marked it. We'll try. We'll try only. We cannot say at this stage.
2 p.m., my lord. 2 p.m.
We'll try. Yes.
2 p.m.
We'll
my
try.
lord.
That's what I'm saying.
May I please, Your Lordship? I beg to mention item number 50, Your Lordship.
50.
50. Lordship, actually, it was supposed to come in motion column, Your Lordship. Again, today also it is listed in orders, Your Lordship. So on the last occasion, it was also directed to list the matter in motion column, Your Lordship. Kindly, this item may be taken as the last item of motion, if possible.
Last item of motion, it is already in order column.
Yes, Lordship.
Then?
But it was supposed to come in motion column, Your Lordship.
So what to do then? You say. Order why it is not there, I don't know. It should be, it ought to be, but I don't know. Anyway, orders column, I cannot say at this stage what will happen. There are lots of matters you see. What kind of do. We'll try definitely.
Yes, may I please, the lord. So I beg to mention one criminal revision, my lord, for this.
May I make a mention before court number 11.
May I please, my lord, I beg to mention item number 53 and 54, my lord. These matters, Mr. D.K. Mishra is leading arguments. However, he has just recently been released from the hospital. It's been quite a while, but he's still undergoing recovery. So, my lord, I pray that some time may be given in these matters.
Mr. Mishra is there.
Mr. Mishra is there. He's recovering. So, therefore, he's not being able to attend court. So, my lord,
You are on 53 and 54.
53 and 54, I am appearing, my lord.
But who is on 50?
Mr. O.P. Bhatti used to appear in 51 and 52. His junior has informed me yesterday he is going to testify for some personal engagement. They also do not have any problem as and when the matter gets listed, my lord.
Mr. O.P. Bhatti is also not available today.
He's also not. I pray, my lord, my only thing is that my prayer is that it may be listed in January, my lord, because
53 and 54, Mr. D.K. Mishra.
these are all connected matters. my lord.
Yes, all connected matters. The Bhatti is also not, as per his information, he may not be available.
And his junior has categorically informed me yesterday.
Okay.
For intimation was done or not?
Yes, sir. Yesterday he categorically informed. Then in
Otherwise, in all cases, Mr. B. Gogoi is appearing.
yes. He's already given his consent.
Consent Likiriba. 53 and 54 all make a mention that Mr. D.K. Mishra, the engaged counsel, is not in a position to, indisposed condition, 53 and 54. And 51 and 52, Mr. O.P. Bhatti is not available. Need to ground us. To come, all are 51, 52, 53, and 54 are all connected matters, in fact. January, no?
January, my lord. Okay. And my lord, 53 and 54 interim may be extended.
53 and 54.
Yes.
Do you know about 51 and 52? Was there any?
They also have an interim.
Interim be extended till next date of listing. Yes, January, second week. Want to fix the date? 23.
Yes, my lord.
23rd of January.
Obligement.
May I please, your lordship? I beg to mention item number 7, my lord.
Item number?
7. Matter may be fixed at 2 p.m.
2.
Yes. Item 1.
It was your lordship. Lordship, it is the 483 BNSS application, Lordship, in connection with the special NDPS case number 1223 under section 20B2C of NDPS Act, Lordship. The petitioner who is in the judicial custody since 26/5/23, Lordship. The FIR is at page 5.
Just a second, you want to, I want to ask you whether it is charge sheeted one,
Such it.
charge sheeted case.
Elsewhere may be called for, Lordship.
It's a commercial quantity case, so we are calling for the case record.
Lordship.
See, it's CR call, LCR case.
A short name may be given, Lordship.
Short to prior vacation, if not possible. Prior vacation is not possible. Once charge sheet is submitted, let us see what is the progress of the case. Because
Evidence,
there are, pardon?
evidence is.
So it's good only within 5-6 months, it is, if it is an evidence stage, very good. Because once charge sheet is filed, if there is no material at all, suppose that is the question will be different,
Actually,
but otherwise, if charge is there, charge has already been framed, I mean, charge sheet,
How many witnesses will be
7 witnesses is there.
then may not be, but whatever, prior vacation may not be possible, may not be, in fact, it will not be possible. After vacation only, January, first week of January, any date goes. 10 January, we have to think.
Okay.
Item 2.
It will 99, today 75 days, she is behind the bar. And allegation that in the area of possibly Sonapur, when eviction was conducted, some people attacked the government employee who were engaged for eviction. About 2,000 people mentioned in the affair. And the present petitioner, as per my instruction, he was lately present there, but he was not take part in the alleged incident. And suspect or some wrong information may be arrested. 75 days. It may consider enough. Already he is in jail.
Case when it also of this plot.
Obviously, otherwise their detention is 75 days.
75. I think he is
90 days of return.
Obviously 90 days offense. Okay, any short date can be given,
18.
18.
18 after 18 only after 90 days. So next
Because
week,
9.
next Monday, well,
Okay, so now.
Nine.
Next Monday.
9th of 12.
Okay. 9.
Obliged.
Item 3.
Please, your lordship. This is the 483 BNSS Act and your lordship, the person was arrested on 3/11/24.
3/11.
Yes, your lordship. And he is from Bhangrabari, Guwahati. And 21 C is applicable by the police.
He is in custody since 3/11.
Yes.
Okay.
So
Call for a case.
after vacation.
It will be after vacation only. No, yes, date can be given.
Anything.
9th of January. 9 January.
Okay.
9th of January. Okay.
Much obliged.
Item 4.
No, just no. That's a 483 BNS lordship. FRPS 12 lordship. There are two prisoners. They are
This is registered under which section?
POCSO 8 and 12. POCSO 8 and 12.
POCSO. So obviously,
Notice to go.
notice to go.
But it's shorter than 49 days of the behind the after. 60 days mandatory period.
I understand, but the question is notice has to go
Yes.
because we have to.
Just for your lordship.
Respondent. Also call for this CD. True. OC, it will go.
Informal
OC?
also lordship. Informal to SI lordship. SI of police lordship. Same PS lordship. Saga PS lordship. Kindly close the FIR lordship.
Oh,
Yes,
it was
yes.
filed through,
SIS lordship. So same PS.
but you don't have any the guardian parents or
No lordship, no address is there lordship. Only the name of the victim lordship. No parents name lordship. Kindly fill the FIR lordship.
Parent's name is not
Yes.
there.
On page number 12 lordship. Address not there, only lordship name lordship. Oromi Boro, daughter of Oromi Boro, village Singra, Novapara. Informer is the WSI Priya Dotto lordship of Soigaon PS. Then two victims, two accused persons.
Notice for the informant, and he will, if anybody wants to appear from the victim side, then in the meantime, case then it will call for.
Then how can you say anybody? It will be difficult. They will not be informed, no, otherwise. One address is there.
Address is their lordship, address is village name is their lordship.
Daughter of so and so.
Yes,
Both are
lordship.
from village. One is from village Singra.
Yes, one is from
Naupara and one is
Noyapara
from
lordship.
village-
Noyapara Piaz Boko. One is from village Boko. From Jobepara.
Jobepara.
Yes.
Both are from Boko, at different place. Now from Zebepara.
Yes, what to do? Kusami.
I will send them in this address, lordship. The address is, what the address from Morami Boro, daughter of Orami Boro, from that address, but here lordship, the informant
WS.
implemented by the WSI.
WS of Soigaon Piaz lordship.
Let us issue first notice to WSI only.
Yes.
Notice issue করে দিও।
In them call for a case there.
So he is a police officer, so with your, only it will be routed through your office and the public prosecutor. Routed through the office of the registry and the public prosecutor. Or through the judicial police station, but he is a police officer. Priya Datta. Also call for the case diary. When can it be fixed?
17.
17. 17 will reach.
49 days.
60 days.
50 days.
Then 13 12.
Lordship.
32.
Item 5.
Lordship, 483 application we left. Application is unauthorized possession of snacks. Petition number
Unauthorized
1,
possession of what?
snacks. Snacks.
Snakes. Acha.
Petition number 1 is the snacks server member, and other two are helper of petition number 1.
Here you are appealing or
Forest.
special PP forest. Special PP forest you have informed? Special PP forest or wildlife, I don't know, but
Sub to the PP office. PP office has taken the copy.
okay. We are just informed.
Item 6.
6-9. 6 কিবা time বিচাৰিছে 2 PM.
7.
Huh? It was 7 again. Oh, sorry, it was 7 then. I didn't. They said 2 PM. Your timing. But it's arrived already. Okay.
For commercial quantity, lots of case diary may be 12.
Commercial quantity.
Commercial quantity. And the thing is that nothing was recovered from his possession, also. So from another person's possession, and subsequently he was arrested. And he was in fact doing the hotel business at Bangalore. He came to Assam to set up his own business and he was residing in his house. From the prime accused, he was having some financial transaction because he assured this petitioner that he will arrange all the necessary documents and help him in the to set up the hotel business first. Accordingly, there was some money transaction. I have enclosed the hotel documents also to show that he was there. But because of that monetary transaction, the present petitioner is arrested in the present case.
Because it has come that
It
much.
has come, except that nothing is there.
Yes,
Case diary and allowance FSL report after vacation.
After vacation, it will be, before vacation, any day we will try out.
before vacation 1920 we cannot give you. 15 to almost.
Commercial continue.
But his implication lordship may only see.
Don't know. Yes, I have submitted. They may not be. Detail. We don't have any dates.
Probably there will be other benches also. So we will try. If the city does not come, I will not.
16 Monday. 16, 17. 16. 16.
Obliged.
Ultimate.
Lordship, in this case, LCR may be called for, NDPS 22C marks. Charge sheet.
Charge sheeted one.
Mark.
So it will come after vacation.
March.
only. We don't have any. Yes, Musami, when it can.
Lordship. Yes. 10.
10, 10 mark.
Obliged.
Item 9.
The petitioner is custody for 35 days as on today, lordship. FIO lordship will find at page 8, start from page 8, relevant person page 9. Here, lordship, total 7 grams of heroin was recovered, and lordship may kindly see the FIR first, which says that one specific information received that may I read the FIR. Lordship. It is to inform you that a reliable information was received from a source by me at 9:15 p.m. Lordship, may I kindly note that time, Lordship. At night, on 28/10/2024. As per the information that one regular drug dealer will be coming from Sapor to Odubi and Balapara area under Jugigupa PS. This Balapara area also, Lordship, may I note, because I am from that place only. In Costatel also my residence is there. Jugigupa PS for selling, dealing illicit trafficking of narcotic drugs and psychotropic substances item. Accordingly, the matter was informed to OC, so this formalities was done. Lordship may skip that part, and after those names, second paragraph, Lordship, we reached at Odubi Bazaar area at 11:10 p.m. waiting for some source signal, and put up all round ambush around the Odubi Bazaar area. At about 11:30 p.m., as per the source information, the suspected person is coming towards Odubi Bazaar area on foot through Jugigupa to Salbari Road. At around 11:40 p.m., I have seen the suspected NDPS dealer approaching towards Odubi Bazaar. So I have seen the suspected NDPS dealer. So he is mentioning about one person. I have also seen 2 other persons along with the suspected NDPS dealer. During ambush, I have seen 1 person concealing suspected item near Idgah field from a distance of 100 meters. So he has seen from 100 meters, and Lordship may kindly note the date 11:40 p.m. at night. On arrival at Odubi Bazaar, they stopped in the grocery shop of Abu Bakr Siddiq, and I have seen chewing betel nut in the said shop. Accordingly, my detailed party, who were already in ambush position around the Odubi Bazaar area, approached near the suspected person in the shop and grabbed the person from behind and apprehended him. As soon as our police personnel grabbed the suspected person, other 2 persons started running away from the spot. Our police personnel chased the 2 other persons but could not caught him. So thereafter, I was apprehended, Lordship, and Lordship may kindly see next page, the quantity of the contraband. 55 numbers of small plastic container of different color in top portion, Lordship. color marked as P1 to P55 containing suspected psychotropic substances, heroin weighing 1 gram in each vial. Total weight of the with container 71 grams and without container 7 grams. Further, so thereafter he was apprehended, Lordship. And only 7 grams, Lordship, he is in custody for 35 days. And from the FIR, your Lordship has seen that it was 100 kilometers away, the place of occurrence. Where which of the accused, Lordship, kept those, whether this person was involved or not, those things are there, Lordship. And in my paragraph 5, I have already stated that on the said date, Lordship, I boarded in their vehicle, the 2 other person who fled away from the place, as they were known to me, Lordship. And while coming, Lordship, that vehicle broke down, and thereafter we 3 were coming on foot to that said area. And I am local resident of that, Lordship. Kindly see page 2, cross title, name of the petitioner, village Balapara. So I was resident of that area. Therefore, I was coming to that place, Lordship. They could not apprehend the actual carriage. Therefore, they apprehended me, Lordship.
But also given a short date, will produce the case after treasure of the case date, Lordship will be said.
Already 35 days, Lordship, he has disclosed everything in the forwarding report. Also, your Lordship will find that he has disclosed the name of the person who were with him, Lordship. Already everything disclosed. Only 7 grams has been recovered. Lordship.
11 CDB will produce the bill.
Yes, 11. You are in 35 days.
35 days.
Only doing 11 only, otherwise 6, 7, 2 is not possible. So we are trying to give you 11, 12.
Alright.
Item 10.
Please, Your Lordship. Lordship, this is a commercial quantity, so CD may be called for only.
Is a charge sheeted case or
No, please, Lordship, I'm sorry. I have that for my
is a charge sheeted one or he is in
No, my
custody?
lord.
He's in
not-
custody?
He's in custody 117 days, my lord. And nothing is recovered from me. I am not the FIR named accused, my lord. I was arrested later on. And 29 is there in the FIR, my lord. The FIR is a page number.
Oh, this is a commercial
Commercial
quantity, we call
Okay.
for a case diary. Yes,
7-1.
7-1. 7-1.
Hello.
11.
Non-appears on call. List after 1.
Item 12.
My pleasure. Charge case, my lord, commercial quantity, my lord. Scan copy of LCR, my lord. So it's 3, my.
It's a charge sheeted one.
Charge sheeted one, my.
He is in custody since when?
Since my lord 14, 5.
14/5. Obviously, it will be after vacation only.
My lord is from Kamrup, my lord.
No, after vacation, we don't have dates.
If not come, my lord automatically date.
No, we don't have dates. Coming is different. That's why.
Immediately, my lord, after vacation.
Yes, stop.
9-1.
9-1.
Obliged, my.
LCR,
Item 5.
yes.
Lordship, petitioners are musician, my lord.
Huh?
Musician.
Ah.
They used to show magic by show snack, my lord. My lord, on 15/11/2024, Lordship, the petitioners used to sell medicine, my lord, showing the snacks, my lord. That is the allegation, my lord. They are sapera, my lord.
Showing snakes, they used to sell medicine. Why?
My lord, kindly see page 8, your lord. 11% at 9, my lord, last. The details of the offense are as follows.
9. On 15/11/2024, at about 10:20 AM, information was received at Ranch headquarters regarding display of wild animals and wildlife articles at Langla Market area of Bongaigaon district. Accordingly, a team was constituted immediately comprising of staffs of Abhayapuri Ranch, and I was made the team leader to lead the operation and rescue the wild animals from the culprits. I, along with the staffs of Abhayapuri Ranch, proceeded towards Langla Market area, where some culprits were displaying snacks and selling medicines. All the snakes has already been recovered from their possession, Mother. That is admitted fact, Mother. My humble prayer, Mother.
So these are the cobra is there,
Yes,
red
ma'am.
snake is
Yes,
the Indian
ma'am.
red snake. Very species different. All are ornate flying snakes. Wow. Sandbara.
Yes, my lord.
These are the snakes.
Scheduled animal, man.
Huh?
Maybe my lord scheduled animal, man. Their forefathers were also, my lord.
No, see, we also heard earlier that yes, Sapera was there. This
Yes,
they
yes,
used
yes,
to
ma'am.
play snake. But nowadays it cannot be.
They are
No,
the
it's
illiterate
a-
person, my lord. No, but they did not know how to take permission, my lord.
Okay, since when they are in custody? 15/11.
15/11, my lord.
Yes, Sharma, anything?
My lord, kindly have a offense report at this stage, my lord. Kindly pick some sorted. From
Offense
Bongaigaon, my lord.
For the offensive.
12, my lord. 12. Even my 12.
12 to 1:30, I think. Na? 13 is a working day? No. Many cases. Then 12, maybe 12. Something. 11 can be. 11 can be from Naga? 11.
My lord, I shall not available, my lord.
11 you'll be not available.
Yes, my lord. Then 16, my lord. 16,
16,
12, 16, 12.
16 12. Offense report for good.
My lord. Hello.
Okay.
30.
May I please, Your Lord? Let's say
Yes.
here initially the case was registered as PS case. After that, Lordship, that case was transferred.
Now it is investigated by CBI.
You need a time to file an objection to this one.
Lordship, here I have to submit for 2 minutes, Lordship.
Copy is also required.
Copy not yet, sir. Copy not, sir.
Lordship, what happened, Lordship? As on that, Lordship, petitioner number 1 has completed 63 days and petitioner number 1 has completed 61 days behind the verse. Now, Lordship, here the coordinate bench of this honorable court had passed an order on sparingly covered case, Lordship, where court has held that the statutory period has completed and in that case, Lordship, the petitioners are granted bail, Lordship. Here, Lordship, my case is similar, Lordship. Lordship, that 2 sections that were added, Lordship, on 14/11/24, after committing to CBI, Lordship, on care of the CBI, Lordship, the Honorable Special Court has added those 2 sections where statutory period is 90 days, Lordship. Initially the case was registered as Kajalgaon PS, Lordship. FIR is at PS, Lordship, on 13, Lordship. So after getting the notification of the government of Assam, Lordship, and the case was transferred, Lordship, it was not a big issue, Lordship. The circumstances are there. FIR is at, Lordship, page number
30.
Yes, Lordship. Allegation is that they had opened 2 societies and collected money for saving, Lordship, and they did not given that money to the beneficiaries, Lordship. One of the beneficiaries had filed a FIR, Lordship, against us, Lordship. We were the FIR name accused, other three accused persons also appeared before as per the instruction given by the petitioner's lordship.
Now, you have supplied this one, this is out of this FIR or?
No, lordship.
Wait,
Sparingly covered, yes,
acha.
sparingly covered case
Okay.
lordship, that's trading case lordship. No,
Lordship, my humble prayer, Lordship, will file an objection to it. One more petition is, I think, pending before this honorable court, which is fixed on 9/12.
For same FIR?
Pertains to Disney PS case number 150.
lordship, it's,
Accused is same, no,
no, this is Kajalgaon PS case.
accused is Tajuddin.
Same accused.
Tajuddin,
That may be different FIR lordship, and
same, accused is same, FIR is different, Lord. It relates to Disney PS case number 150/24.
lordship, we are,
Fixed on 9th of December.
lordship, that's it, I have given to you lordship. So paragraph number 35, the coordinator bench had stated that admittedly the charge sheet was not filed within 60 days in this case, as it appears that the accused petitioner was arrested on 04/09/24 and the case was registered under sections 3162/318 subclause 4 of BNS, reduced section 2123 of Bats Lordship, banning of unregulated deposit scheme act lordship, wherein mandatory period of custody is 60 days. Section 409 IPC was added on so and so. By that time, the IPC was repealed, lordship. Here in this case also 409 was added, lordship. That will be repealed. And section 16 subclause 5 of BNS was added on so and so. And during such period, the mandatory period was over, lordship. Hence, the petitioner is entitled for default bail, lordship. So my submission is that, lordship, we are behind our last 61 and 63 days respectively for the both petitioners, lordship. Now on the
So in regards to adding of 409 or 316, your submission that there was not, it was already been repealed.
yes,
That
lordship.
is
Yes,
the
lordship.
submission.
Yes,
Okay.
lordship. So considering it, I may be allowed to go bail by default
Now
bail. may
he
be
there want to,
granted.
they want to file their written objection.
Yes.
So
He is seeking 9th.
9.
So
In another, one more petition is there, I think.
Yes,
it's separate affair.
whatever.
That one is a separate affair. Business PS. My PS is Kajalgaon PS, lordship.
This matter was listed prior to this matter, lordship. It has been fixed on 9/12. Let both the matter be heard together and disposed of.
9th only.
The informant is separate, my informant is separate, in this case separate, lordship, I mean.
Accused is same.
Accused are same, lordship.
That means they are the
Collectors.
Address is our time within. Abonali, no, that Tajuddin is different, lordship. That Tajuddin is different. My father name is Aban Ali, and that one is different, lordship.
maybe.
That one is different, lordship. So that is different, lordship. So
But for him, most probably it will be more easier because almost same
Law point will involve.
Yes,
law point will
lordship,
be
lordship.
involved. So we are fixing it on 9th.
Lordship, so that can it be on 6 or 5, lordship?
5 and 6, there are no dates at all. No, nothing. All are full. You can see we have already fixed 9 and 6. Will it be on 9th? 9 is also, yeah, not in a position to give because
Today
prior-
is 2, lordship.
Huh?
Today is 2.
Ah.
And after
7 days, 9/21. 9/20. Praying, Mr. Harvey is praying for file the objection. Prayer allowed. List according to the 9/20 for filing objection by the council seat. We are 9/20.
deeply obliged.
14.
May it please your lordship. Lordship, item number 16 also arises from the same FIR, my lord.
16.
Charge sheet. Yes, my lord. Both can be taken up together, my lord. Today only for calling of LCR also possibly. Even though charge sheeted, my lord. My lord, the primary accused persons were arrested in the month of May. That is very important. In the forwarding report at page number 20. Then subsequently, my lord, in the month of September. Not red-handed, my lord, not with the possession also. Just because our mobile was also found in the same area, the petitioner was arrested, my lord. That lordship would find my forwarding report at page 32. understand, my lord, as because commercial quantity is involved, even though I was not caught with the, my lord, the alleged products, possibly LCR will be required, my lord. Charge sheet already submitted. Only one line against me, that CDR says that I was also involved in that area, that is page 44. Even though, my lord, no material, still LCR possibly will be required, my lord, because of the allegation, nature of allegation. So, my lord, may I pray after 2 weeks, my lord, similar matter of the same accused persons are, my lord, LCR already called for.
Can you tell us the date?
My lord, because in that matter, date was not fixed, my lord. Call for LCR fixed after 2 weeks. It was passed in that manner, my lord. So that is why, my lord.
Call for LCR, list after 2 weeks. If it comes together, then it will okay.
Lordship.
Both 14
LCR
and 16.
14 and 16, my lord, same order. My lord, it may be reflected LCR from, my lord, learned special judge come additional session judge, Karimganj, my lord. That may be reflected, my lord, after 2 weeks, my lord. Both, my lord.
Yes, both. 14 and 16.
14 and 16, my lord. If lordship pleases, lordship may fix a date like 16, 17, or my lord. as your
16,
lordship
17,
deems.
that's why I'm saying 16, 17 is not at
My lord, we'll see, my lord, we'll see that.
If after 2 weeks regular course it comes
Regular
up before
course.
16, 17, then it's okay. I'll be.
Point taken, my lord. Deeply obliged, my lord.
The prisoner is behind bar for 25 days, Your Lordship. Your Lordship will kindly come to page 14, Your Lordship. Type copy, Your Lordship will get it at page 10. Essentially a case under 67A of information technology. They suspected me, Your Lordship. And Your Lordship, forwarding report is, Your Lordship, page 16.
16.
Page 16. Here, in fact, Your Lordship, further custodial detention probably may not require, Your Lordship. They have to. Your Lordship will kindly come to page 19. He was thoroughly interrogated, Your Lordship. 5 days police custody was granted. Now in the jail custody. Probably, Your Lordship, further custodial detentions may not be required, Your Lordship. The nature of this.
Okay, what is the case, right? Lordship and lordship will decide. After closing the case.
25 days behind bar, Your Lordship.
There may be question of FSL also.
Lord.
You just ask if it is FSL is there. If it has already been sent to FSL. In such nature of cases, generally we see that FSL report is required. So probably also you try to collect the FSL report also. Along with the FSL report going up now. We don't know where this present state,
Lord.
but still we are calling it.
Lord. It is from Guwahati itself, Your Lordship. Cyber police district.
That is to understand, but we don't have dates. In fact, prior vacation, almost
Before
for that-
vacation, one day, Your Lordship.
Before vacation, we don't have dates. Huh? It's full only. How can we say? বা পাৰিব উলিয়াব নহ'লেতো উপায় নাই।
Before vacation.
Before vacation, we 19,
One
20
day.
we cannot give.
17,
19 and
16, Your Lordship.
17, 16 is almost full.
Ultimately, Your Lordship, by January, Your Lordship, you virtually, Your Lordship, 60 days.
Mandatory period of warrant.
Okay, 17, 20.
Lords, deeply obliged.
Item 17.
Please, Lordship. Also, with the charge sheeted case, Lordship may call for the scan copy at this stage. When POXO is there, Lordship, so notice should go to the informant.
POXO is there.
Yes, Lordship.
Otherwise, it's a charge sheeted one.
Charge sheeted one. He is in custody since 24/6.
Issue notice করে দেব সন্তোষ স্যার, হ্যাঁ? through Hiri, judicial police station, short, go to border blame and and also called for the scan copy of deals. The case is pending where now at present?
Is pending in the special judge,
Dalguri.
Dalguri.
Special judge Dalguri. It will be obviously after vacation.
Yes, Lordship. After
10-1.
That is
10
after
January.
Bihu vacation.
After Bihu.
After
Bihu.
And 21, 22, any date?
After vacation. Okay, list after vacation.
21.
21.
List vacation.
80.
Wait, please, Your Lord. That POCSO is there, my lord, notice my report.
15 name is not reflected.
My name is not reflected, that is why, my lord. Rest may be directed, my lord, my name may be shown in the
Obviously.
this, my lord.
You are Mr. Bhuya?
TK Bhuya, my lord.
TK Bhuya. Heard Mr. TK Bhuya, the learned counsel for the petitioner, and also heard Mr. MS SG Bora, the learned SG, na? You are? Oh, sorry, SH Bora, the learned additional PP appearing on behalf of state respondent. Okay, to Hirigo. It's a POCSO, na?
POCSO.
Matter notice to
POCSO notice credible. And registry is also hereby directed to reflect the name of Mr. TK Bhuya in the cause list and the next data listing. We have been directed.
3rd of January, my lord.
3rd January can be okay.
Deep left.
90.
Watching regular bail application under section 483 of NDPS Lordship. Petitioner is behind the bar for last 34 days. The offense Lordship under section 74 of the BNS and read with section 8 of the POCSO Act. Lordship. The FIR Lordship as such, there is no such allegation Lordship, but since POCSO is there, the respondent needs to be Lordship served.
Now, since when he is in custody?
He is in custody since 30 October. 34 days today.
days as on today.
34 days. There is no as such
Otherwise,
allegation.
it says 60 days offense act.
60 days.
Yes, Lord.
Issue notice corridor through registered. Okay, through judicial police routed to the office of the public prosecutor and raised. So after vacation, it will be over before vacation.
Yes, on 18th or 19th.
Lordship wants 16 Lordship.
It's from Tinsukia.
Tinsukia it will come Lordship, but
On 18th, we can try.
till 16 Lordship 48 days. 14 days.
What? It is 60 days offense. 18, you are saying on 18th.
18th.
18th. for it.
CD along with the statement of
CD, yes. CD. Call for the CD along with the statement of the victim. Or baki notice is super card. 18th of December. Okay.
Oblige.
20. Let me your lordship.
Yes.
It's a 483 application lordship. Petitioner was arrested on 6/8/2024. In this case was registered under 6 of POCSO Act along with the section under section 87, 64 to M BNS. Charge seated method. Notice should go to respondent number 2. Respondent number 2. In the meantime, LCR may be called. In this case, lordship, charge sheet should go through the PP lordship to the concerned police station. It will be easier.
Yes. Through concerned police station.
Yes,
Through
through the
office of the.
Through registry, then.
Yes.
She will provide us.
Yes.
As per notification
Yes,
70.
judicial police station routed to the office of the registry and the public prosecutor. You take steps there, and we are also calling for the scan copy of the LCR.
Can it be before vacation?
Before vacation, not possible.
In the
It will
first
be
week
after
of
vacation. First week of January can be. You want any date fixed? Or after vacation?
Receiving,
Yes.
after just
Immediately after receiving. Oh, after
But it's
vacation,
from-
immediately receiving after the case record.
Lordship, special just POCSO Morida.
We'll make sure.
Yes. No problem. 21.
Met is a lot.
Yes.
We have filed this petition, my lord, for quashing of CR case, my lord. Filed under, my lord, section 12 of DB Act, my lord. What happened in this case, my lord, the marriage took place in 2016. Then, my lord, in 2018, my lord, the wife left the house of the husband. Then, my lord, husband filed a petition, my lord, seeking restitution of conjugal rights. Wife filed, my lord, a criminal case, my lord, under section 498A. And thereafter, my lord, wife filed another case, my lord, under section 12 of DB Act.
Hmm.
3 cases were going on, my lord. Finally, my lord, the petition was acquitted in criminal case. She withdrew the first DB case, my lord. And thereafter, they started to live together for some period. Again, she filed a case, my lord, under section 125 CrPC seeking maintenance. During pendency of this case, my lord, the present case has been filed by suppressing everything, my lord.
Now, what is the position of 125?
Now, I have appeared and submitted my written statement.
But the prayer to, I don't know, what is the section 12? There are other prayers also, I think.
My lord,
Apart from monetary relief, was there any other prayer?
my lord, they
Where
have
is the petition?
they have tick mark page 19, my lord. They fill up the form, my lord, by
So
ticking all,
residence order prayer is also there.
by ticking all the, my lord. Basically, my lord, monetary relief is main. my lord.
Yes, obviously, monetary relief is there.
Law.
Residence order is there. Protection is also there. The other prayers and other reliefs are there, no?
Now, she is living at her husband, parents' house since, my lord, 2018. In criminal case, the petitioner has been acquitted by the trial court.
These are there, but
Lord, by suppressing everything, my lord.
DB matter. Let them appear, then only we'll see to regarding the stay and all. Hard history,
Similar case, earlier, my lord, same allegation, my lord.
yes,
First DB case 58, my lord, case 58.
yes, obviously now at
Lord.
present suppressing the all the matters and the pendency of the
But same
125.
Proof case has been filed.
No, presently
Lord.
125 and DV.
Lordship,
DV is subsequent to 125.
They filed on the same day, my lord. Date is same, my lord.
Same day.
Same day. Page 89, my lord. On 23, 3/11/23, my lord.
No, DV is
3/11.
311.
125 also 3/11.
125 also 311. Same day.
Lord.
Or Mr. R. Ali Dilanet counsel for the petition. And this is an application under section 550, 528 of the BNSS for quashing of this CR case number 850 of 2023 pending in the court of Learned SDGMS Borpata. Stop issue notice for you. To the respondent to register DD and as usual process. Also called for the scan copy of DLC. Next para, it is submitted by Mr. Ali that the earlier 2 cases were filed by the present respondent. One under section 498 AIPC and another one was under the DB Act. But in criminal case, the accused, the present petitioner got acquitted, and subsequently one DB Act was earlier. DB Act was also withdrawn by the respondent, and they started together as husband and wife. But after some days later, she again lost one case under section 125 CrPC seeking maintenance, and the present case under the DB Act. for same relief, suppressing her petition filed under section 125 CrPC. Accordingly, he prayed for stay of the further proceeding of the present DB Act, DB proceeding. But considering the nature of the proceeding, this court is of opinion, proceeding, the stay order may be considered after appearance of the respondent. Let the matter be fixed accordingly after 3 weeks, and prayer on stay may be considered accordingly. Question? It is taken. It is a DB matter. I won't go find to pass any order on stay at present. Let them appear on the next date. We'll try to first.
Yeah.
3 weeks.
22.
Ma'am, the instant petition, my lord, under section 428, my lord, for quashing of a affair, which was registered on 4th August 2014, my lord, for defalcation of excise duty, my lord. And after 2 months of the same day, the excise department has lost another complaint against me, my lord, 2014. Subject in 2023, my lord, they have a complaint lost against me, my lord, for the defalcation of the excise duty. They have withdrawn. According to the trial court has acquitted me from that case. Now my question is, my lord, why I am before this court, my lord, might take that the affair, my lord, annexure 2, page 15, my lord.
Oh, so just a second. Respondents, yeah, excise is appearing.
Last occasion, also Lordship heard this matter. That because of his presence, my Lordship has fixed this matter today.
What to do? Say
Yeah.
what to
So,
do.
Lordship-
Can you just inform me? Just we are informing, just for
Yes,
timing.
yes, my lord. Yes.
23.
My please, Lordship. In this case, petitioner is agreed with the issuance of P&A along with NBWA against it. Petitioner was on bail granted by Honorable High Court. Lordship may kindly come page 19, Lordship. This is the order of Honorable High Court. At page 20. His bail bond was submitted before Learned Chief Judicial Magistrate. Now, Lordship, may kindly come to page 33.
Where page 20?
Page
19 is the bail order.
19 is bail. 20 is
20 is the continuation of bail order.
continuation of the bail order before Learned Chief Judicial Magistrate bail bond was submitted.
It was directed. Have you furnished the
Yes,
bail bond?
yes, Lordship. Yes, Lordship. Now, Lordship, may kindly come to page 33. 33. Here, summon was issued. Summon was issued, may I please read? Summons issued to the accused is returned unserved with report that he is not found in the given address and nobody could say his whereabouts. Hence, issue fresh summon against the accused. So, fresh summon was issued. On next date, Lordship, page 34. Summon issued to the accused is not returned. Is not returned. On perusal of the case record, it is found that the summons has been issued many times to the accused, but every time it returns with same types of reports, such as the accused is not available in the given address, and nobody knows about his whereabouts, which reflects the accused is avoiding trial. Considering the above report, and as it also an old pending case, I deem fit to issue P&A along with NBW against the accused person. The Lordship, summon was not returned, and there was no report. Earlier report was considered. And I have annexed, Lordship, this is my permanent address. What address has been given in the, this is in Tinshukia. Annex my Aadhaar card, this voter ID. This is my permanent address. My entire family resides here, the joint family. I have made statement also in this respect. Now, P&A cannot be issued directly, Lordship. This section 82 of CrPC or the new P&A directly cannot be issued. And here P&A issued directly with NBW. Now, sole purpose is for appearance, Lordship. I will appear. This is apparently order is illegal. I will appear and I may be allowed to remain in the previous bail on, and I will appear. Next date fixed on 24/12. And subsequent 2 orders are also there. There is also issue of fresh P&A also. Page 36 is the last order. Next date fixed on 24/12.
But in their, order dated,
Lordship,
19/7,
Lordship,
your PNA was issued along with NBWA.
along with them.
But subsequently, in 20/08/2024, no NBWA was issued,
PNA.
only PNA.
So that's why these are entirely illegal. All the orders are illegal. That is why I prayed for setting aside of this order and also with a prayer to allow me to appear before the court and remain on previous bails. It may be
Yes,
disposed
Bora.
today itself.
Yes, Lordship, the suit was filed in the year 2025, 2015, Lordship, 2015, and my learned friend has annexed the order sheet from 2024 onwards.
Yes.
So what was happened with during the period from 25 to 23, Lordship? It's a long period. It seems he is evading arrest. He is found to be absconder, it seems. No,
Summons
There
was
is a-
issued. How can I is absconded?
because on several occasions, someone was issued. So it is going to be served because
In the, to your submission also here in the 19/7 also, there's a reflection that many a times, yeah, summons were issued, all the times it has returned unserved.
trial.
Mhm.
We also, since he is inclined to face the trial, but it is fixed on 24/12. But let him appear before the 24th.
Mr. S.D. Pulkast. Heard Mr. S.D. Pulkast, the learned counsel for the petitioner, and also heard MS S.H. Bora, the learned additional PP, appearing on behalf of state respondent. This is an application under under 528 of BNSS. Corresponding to whole, no, it's 528 of BNSS for setting aside and quashing of the order dated 19/7/2024 and the other subsequent dates whereby the PNA and NBW was issued against the present petitioner in connection with GR case number 4790 of 2008. Next, right, it is submitted by Mr. Pulkast that the present petitioner obtained his bail order from this court, which was granted by order dated. Where is the annexure?
Page 19, 4/5/2012.
Dated 4/5/2012 by this court in connection with bail application number 962 of 2012. There and after filing of the charge sheet, these summons were issued against the present petitioner. But subsequently on 19, no, sorry. On but summons were issued so and so, but subsequently on 19/7/2024, the NBWA along with PNA was issued against the present petitioner. With an observation by this court that as the summons returned many times against the accused petitioner, the PNA was issued. However, first off, the present petitioner never received any summons from the court. And after issuance of the PNA only, he came to know about the fact that the case has been charge sheeted. First off, he is a permanent resident of his address locality wherein he stays along with his family members, but without serving any summon to him. The court passed the order of issuance of NBWA along with PNA. And accordingly, he submitted that he is ready and the petitioner is ready and willing to appear before the learned trial court below and to contest the case if he is allowed with some interim, if is granted with some interim protection. And also paid for washing and setting aside of the order of 19/7/2024 and the subsequent orders. Poster. Next para. MS Bora, the learned additional PP submitted in this regard. That from the record, it is seen that the charge sheet was filed on 2015. And the petitioner annexed only the orders passed in the year 2024. But there is no order of issuance of summons in long years of 2015 to 2024. However, she submitted that one chance may be given, one direction may be given to the present petitioner to appear before the learned trial court below and to contest the case accordingly. Next para, considering the entire submission made by the learned counsel for both sides, materials on the case record, and the annexures filed along with the petition. Vis-a-vis the order sheets, this court is of opinion that the petitioner may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. However, till his appearance, that is 26, na? Well, 24, till his appearance, that is on 24/12/2024, the PNA and NBW issued against him may be stayed or be suspended. You appear before the learned trial.
I may be allowed to remain invisible because
No,
I.
no. You appear, she may consider appropriate application, but there may be previous also. Once NBW is it is not possible.
Oh, bless you.
Dispose of query.
24.
May I please your worship? My lord, in this criminal petition, my lord, we have challenged the, my lord, order of granting maintenance to the wife. My lord. First, my lord, magistrate, my lord, granted, my lord, maintenance allowance to the wife at the rate of ₹8,000 per month, and to the son, my lord, 4,000. Then, my lord, in revision, my lord, the Sessions Court, my lord, it has reduced the maintenance of wife from 8,000 to 7,000. Keeping the, my lord, the son's maintenance is 4,000, my lord. Here, my lord, we have challenged on the ground of, my lord, desertion. I am, my lord, ready to pay the maintenance, my lord, to the son, my lord. And, my lord, till the last month, my lord, we are paying the maintenance, my lord, as ordered by the, my lord, Sessions Court, my lord. To both the parties, my lord, wife and as well as the son. And till now, my lord, as per our instruction, there is no area, my lord. Only thing, my lord, whether, my lord, as per the evidence, my lord, whether, my lord, desertion has been proved or not. My lord. Because, my lord, my lord, SSB constable, my lord. So, my lord, he has to, my lord, move around, my lord, all over the country because of his, my lord, nature of the job, my lord. So, at the time of, my lord, the birth of the, my lord, their son also, my lord, at the, my lord, time of the delivery of the wife, my lord, he could not come, my lord. So, my lord, after 8 days, he came, my lord, and all the hospital expenses, etc., everything were paid, my lord. And, my lord, she left my house, my lord, in the year, my lord, 11/6/2017. There, my lord, she has alleged, my lord, mental and physical tortures and, my lord, sexual harassment, my lord. And also with relation with some other person, my lord. And to that effect, my lord, one ZR case was also, my lord, instituted. And that case, my lord, we got acquitted, my lord. That could not be proved. And, my lord, I offered myself, my lord, to make payment. I asked for her bank account also, my lord. But she did not give the bank account also, my lord. In that case, my lord, whether, my lord, I am entitled to pay the maintenance to the wife, my lord. We never neglected, my lord. And I was ready to pay the, my lord, the money to her bank account also. But she did not, my lord, give the account, my lord. And it has come in the evidence also, my lord. If we, my lord, go through the evidence also, my lord. She has admitted all those things, my lord.
Oh, my lord, my submission before your
I mean,
lordship,
session court is also upheld the other, only the reduction was there.
only my lord 1,000 it has been reduced.
But discuss on that, be honest.
Session post never discussed, my lord, about the desertion ground, my lord. It has stated that on the quantum of maintenance, my lord, which we, my lord, never raised, my lord. Quantum of maintenance is not the issue, my lord. Our ground was desertion. But my lord, the sessions court, my lord, it has reflected in the, my lord, that order. Bone of contention is the quantum of maintenance, but that was never the issue, my lord.
Okay, at this stage, we are issuing notice.
My lord.
We're calling for a case, LCA. But stay cannot be there because it is a maintenance case. Let it stay.
That is there, my lord.
Then next week, no, sorry, next date, if she appears,
My lord.
we'll try to dispose of the matter in the admission stage itself. Otherwise, because you are still paying, so why?
That is there, my lord. Marriage is admitted, child is also, my lord.
Paternity is admitted.
Yes.
So desertion ground was not discussed in by
By the, my lord, the sessions court,
sessions,
my lord.
but in the
In the
learned
trial court, my lord, they
it
have.
was discussed.
Yes. But our evidence was not considered, my lord. Defense witness, what we have given, my lord, that was not considered.
No. Mr. PM Chaudhary, the learned counsel for the petition. This is an application, liquidative, so and so, in connection with so and so, against the order passed by the learned session judge in criminal division case number 17 of 2019, dated 30/04/2024, whereby the order of
Monthly maintenance of rupees, my lord, 7,000 per month to the wife, my
yes,
lord,
yes, whereby
and 4,000 to the son, my lord.
order of learned edition CGM Bongaigaon in passed in miss case number 59 of 2018, dated 30/07/2019, was slightly altered by reduction of the order of maintenance towards the respondent number 1 to 8,000 to 7,000. Issue notice corridor, also called for this and so corridor. Let the matter be listed accordingly after 4 weeks. LCR call corridor. 4 weeks will do.
After 4 weeks.
After 4. If take steps, we'll try to dispose of the matter if it comes in the admission.
Opposite, sole opposite party, my lord.
Sole opposite party, yes.
Not one. I'm obliged.
Only respondent number 1 now.
25.
May I please, my lord? This is the application for quashing the FIR 171/2023. My lord, please come to page number 2626. This is the FIR.
Just a second. If you supplementary file. Because motor photo even this put one we are you know how they can report. Suppose if one report yes.
Yes. This is the application for quashing the FIR Laluk PS 171/2023. Under the section 304 IPC, GDR number 72. My lord, kindly come to page number 2626. That is the FIR. Here the petitioner is the principal of the school. Subject
Page
is
number, page number
2626,
2626.
my lord.
Hmm.
Subject FIR adjourned against the St. Xavier School Harmony Authority. The informant is the father of the deceased. May I read the
Yes.
With due respect, I beg to state that my son Jishu Hazorika was healthy student of St. Xavier School studying in class 12. On dated 30/8/2023, my son has gone to school, and on that day, it was extremely hot. This is extremely hot is to be very noted point, my lord. Weather. I came to know that time around 10:20 a.m. Suddenly, my son collapsed in the classroom. In the meantime, his classmates lifted him and they made him to sit on the bench. And thereafter, my father of the school was informed. That is the petitioner father means here. After knowing the accident, the school authority did not take any care in spite of the fact that my son's seriousness condition and the cost to death. To save my son's life, they did not intimate necessary steps and also did not inform to guardian of the student. Next line, the school authority should have taken nearest hospital or call for the 108 ambulance and could have saved the life of my son. The most important line is that, my lord here, due to the school authorities' negligence, as a result, my son died in the school on dated 30/8/23. This is the allegation, my lord. Now, kindly, my lord, come to the page number 3 to 32, where we got the subsequently the father, the principal of the school applied for the pre-arrest bail. There's the second line, my lord, in page number 32. I am of the considered view that the case diary should be called for to consider the bail application, and in the meantime, the accused petitioner should be granted interim anticipatory bail at this stage. Accordingly, let the case diary of Laluk PS case number 171/2023 be called for. In the meantime, it is directed that the accused petitioner, Reverend Father Tyers Bargis, is the principal of the school. In the event of his arrest in connection with the Laluk PS case number 171/2022 shall be released under interim anticipatory bail on furnishing a bail bond for the sum of ₹50,000 with a suitable surety of like amount to the satisfaction of the arresting authority, but with the following condition. 1, 2, 3. 3 condition is the most important, my lord. That during the investigation, the accused, the petitioner, shall not leave the state Assam without previous written permission from the court of learned Chief Judicial Magistrate Lakhimpur and not Lakhimpur. Now, kindly come to the page number now 3838, my lord. In view of the above, the anticipatory bail applications of the accused petitioner, Reverend Father Tyers Bargis, stands allowed, and consequently, the term anticipatory bail granted in favor of the accused petitioner, white number dated so and so, is made absolute on the same term and condition. Here now, for my lord, the petitioner, the father, the principal of the St. Xavier School is likely to be transferred from the Harmony St. Xavier School to Kohima Don Bosco School. And now, my lord, come to page number 44, that is 44. There is a final report. Police has submitted the final report, FR. May I read the portion? 44 page number, my lord. The report of the FR.
Ultimately, the matter has been ended up in the final court.
Yes.
My effort has been submitted at present.
Yes. May I read the portion?
So what do you need now?
Now, my humble prayer is that the affair may be quashed because I am a Salesian father, Don Bosco, working in the Harmony St. James School, and I'm already
It is
transferred.
FR.
Yes.
Ended up in effort.
Ended in FR.
Yes.
Page 44 of it.
44. During the investigation, the previous IO has visited the PO, drawn a rough sketch map.
No, now what is your prayer?
My prayer is that this FIR may be quashed. For quashing FIRs.
FIR.
Yes.
FIR one.
FIR.
Oh, why?
I want my prayer, my humble submission is to be quashed there only. though the FIR is given, still the matter is pending in the lower court.
Yes, what is the legal position now?
Already matter has been ended up, Lordship. Final form, FR has been submitted, Lordship.
Ah.
Now he's coming for quashing of the FIR.
No, there is no existence of FIR is not there now.
No, madam, just someone you take Korea, maybe someone for FIR. Because
Okay.
Someone?
Someone person.
Someone?
Yes, they have summoned to the petitioner.
Oh, obviously someone may be there because after filing of the FIR, there's a procedure that the petitioner or the complainant maybe issued a summon that whether he has any objection and all in, accepting the FIR or not.
My
That is maybe there.
Now
That
petitioner
is
is,
that is the formalities or some procedure only.
Yes.
now at present the petitioner would like to go to the transfer place, that is a Kohima Don Bosco College, and because of this case, he is not in position to go to that transfer place.
That's what you want to submit.
I'm not getting his point actually.
Yeah, we also have problematic it is there.
Let him appear, Lordship, since the final report is already submitted. So there is no question of proceeding
Unless and
against-
until
yes.
suppose your
If Narazi petition is
Narazi
filed by-
petition accepts or if on that basis, if
Yes.
any case has been registered or CR case, whatever is registered, suppose, in that case only we will be in there.
It
But
has to be
at
there.
presently, there is nothing. What to do now?
Petitioner is apprehending that he is in position to go to other place, because of that only is scared.
So if
Other
someone is
place
in
now
the
see
case-
la the bail questions, the bail conditions, etc. This now at present there's not in existence because file and report has already been.
Yes.
My
Now
lord,
it will appear or cause of action will start now only
my lord.
if the magistrate or to take cognizance in that regard. But at present, I don't think it will be hamper you anyway.
So let him
Otherwise,
appear, let him see the legal position, what is there.
Ah.
If any Narazi petition is filed by other party,
No, the-
then the thing will be different also.
কথাটো বৈ খাই আছে ন?
Now, do you have any information whether Narazi petition is already accepted, cognizance has been taken? Because in your petition, nothing is there.
Nothing is
So
there.
bring all these these things into the records and then only we'll listing it in some other day. Because now one point is there, if you have submitted that you have received the notice or summon, whatever, your petitioner has received.
Any
No.
notice has been received?
Your petitioner has
No.
received the notice.
No,
Who received the notice then?
no, to the complainant, they have already issued a summon,
Obviously, they
inform-
will issue.
and now the petitioner is like, wants to transfer from the one place to another now.
That's what I'm saying. Petitioner will definitely, the informant or complainant will definitely receive a notice because matter is already ended in FR.
My
Suppose if the petitioner or the informant or complainant, if he has some kind of suppose objection in allowing or accepting that FR, then matter would have been different because then in that case you may receive a summon or not. But at present, neither your bail petition or bail, terms and conditions of your bail, it's not in existence now. All are gone, in fact. If you want to take instruction, then we may release the matter after some day after. Otherwise, I don't think.
Then I will withdraw my, then I will
We
withdraw.
don't withdraw it, collect some other information if it is not there. Then only you come with a fresh
May I
petition.
allow to withdraw my petition?
Now we want to withdraw this one.
Yeah, I will.
Okay. Withdraw this one.
There was nothing left, Lordship.
We'll defer this.
Yes.
And then the matter has been, final report has been submitted.
Mm. Pero নাম তো দিয়ে দিব। Submitted that this technical reasons he wants to withdraw the same and accordingly prayer allowed, disposed of on withdrawal. You want any fresh prayer?
No,
Liberty you need.
Liberty.
Present liberty you need.
My lord.
With a liberty to file afresh, if so advised. Okay, it is disposed. Otherwise, it is disposed of withdraw. See subsequently if it appears.
Yes.
26.
May I please, Your Lord?
Yes.
Receive application under section 520 of DNS double S, my lord.
Mm.
Petitioner is Lady Constable, serving in Assam Police, your lordship.
Constable.
Yes, my
Ah.
lord. And now she is agreed with the NBW issued by the Learned Judicial Magistrate First Class Guwahati, your lordship will find at page 18. 18.
Page 18.
Yes, your lordship. This is the 12/11/2024. Complaint is absent, 5 steps so and so, accused is absent. It is fresh NBW has been issued, your lordship. And the police has been also given adequate time to execute that NBW and to produce her before the that learned court below. So prior to that, your lordship, may I take your lordship to page 13, your lordship. 13, your lordship. Order dated 9/8/24. Lordship, the available warrant of arrest was issued actually. And the petitioner was not aware of that. And that was also answered on her. 9/8/2024. Page 13, your lordship. On that day, available warrant was issued. And that was answered, and that is reflected in the order dated 3/9/2024, page 16, 16, your lordship. 3/9/24. Complainant is absent with steps by petition so and so. Accused is absent. BWA issued earlier is returned answered, your lordship, with an endorsement stating that he is not traceable in the given address. However, his phone number could be obtained. Issue NBW, right? So that was answered, but on that particular day, NBW was issued, your lordship, and the fresh NBW, that is, so far I have pointed out, 12/11/2024, that is fresh NBW is issued against, your lordship. So my humble prayer is that, your lordship, that was inadvertently happened, your lordship. My humble prayer is that I may be allowed to appear before the learned court below. Until then, my lord, adequate protection may be provided.
But it's not a case that dependency of the case was not, you are not aware of about dependency of the case, because on 18/6 only your
Yes,
steps was taken again for you.
Yes, my lord, I have annexed the order, page 12. Your lordship will find. So actually the case was transferred from the court of Srimati Kaveri Bhattacharya to the court of Dimbeshwar Roy. The case record was transferred to another court. That is on 8/4/2024, your lordship. So prior to that, because of the health advisory and all during 21 and 22, that way, that was adjournment was there. So the next page is 13, 18/6/2024. Since the Wakalatnama file on behalf of the accused, the loss. Wakalatnama is filed. Fixed on 1/8/2024 for service report and appearance, your loss.
That's it.
That's it. So my humble prayer, your lordship, that's the available warrant of arrest that was also answered, and the petitioner was not aware of that. She is ready to appear before the learned court below, my lord. Some protection may be given. She is serving in the Assam police. So government employee, your lordship.
Yes, Bora.
It's a complaint case, lordship. In that
Oh.
regard, notice should go.
You are a formal party here.
Yes.
Heard Mr. D. Bora, the learned counsel for the petitioner. Also heard MS SH Bora, the learned additional VP, appearing on behalf of State Respondent of Marital.
My humble prayer, your lordship, the NBW execution of that NBW that may be stayed by your lordship, and in the meantime, she will appear before the learned court.
And this is an application under section 528 of BNSS against reemption order dated 3/9/2024, 8/10/2024, and 12/11/2024 passed by learned GMFC, come of M, whereby NPWA is issued against the present petitioner in CR case number 2234/2024. It is submitted by Mr. Bora, the learned counsel for the petitioner, that by order dated 8/4/2024, the case was transferred from Court of learned GMFC Srimati Kaveri Bhattacharya and transferred to the Court of learned GMFC Dimbeswar Roy, Kamrup M. Next date of listing, that is on 18/6/2024. The accused was, if the present accused petitioner was appeared through his engaged counsel by filing Wakalatnama. And on 9/8/2024, he was remain up unrepresented, on which date
Yes.
BWA was issued against him. BWA of rupees 10,000. BWA of rupees 10,000 was issued against him. And the next date was fixed on 3/9/2024.
P924, my lord, BW.
But on 3/9/24 also, it's seen that the BW return unserved. But and unserved, and on unserved, and on day itself, the NBW was issued against the present petition, against present petitioner, and subsequently on 8/10/2024 and 12/11/2024 also, Prince NBW was issued against the present petitioner. It is further submitted by Mr. Bora that the present petitioner is working in a where
Assam Police, your lordship,
Assam.
presently posted at Police Reserve, Panbajar.
Assam Police and presently posted as Police Reserve Panbajar.
Under jurisdiction of Commissioner of Police.
Panbajar, and hence the and Panbajar, and in spite of the fact the BW was returned unserved, and even after that the NBW was issued against him or her without receiving any report on BWA. However, the present petitioner is ready and willing to appear before the learned trial court below and to contest the case accordingly if she is given some interim protection. Next, para, considering this submission, Mr. MSH's para submit learned additional PP submitted in this regard that they are the formal parties in this case. However, the petitioner may be directed to appear before the learned trial court below with an appropriate application for the bail. Next part. Take a break. I'll take a break. Considering next para, after hearing the submission made by the learned counsel board boards, I have also perused the case record, and accordingly it is seen that the petitioner was duly represented by her and his counsel. However, on 3/9/2024, she was not represented by by her engaged counsel, on which date the BW was issued, and without proper service of BWA, the NBWA was issued against her. Considering this aspect of the case and also considering the submission made by the learned counsel for the petitioner, she may be directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. However, till her appearance on the next date, where is the fix?
It is 26/12.
Next date, that is on 26/12/2024. the NPWA issued against the present petitioner may be stayed or suspended. With above observation, TNS is disposed of.
Much obliged.
Of filing the FIR is 21/6/2024. May I read it?
Yes.
That the humble prayer of the informant is that I purchased one motorcycle bearing number so and so in the name of my wife through Hero Finance from Orissa Motor Hero dealer Jonai on last dated so and so on monthly installment basis. While I was regularly outside Jonai in connection with my work, the accused number 1, as per the direction of accused number 2, by introducing himself to be an employee of Hero dealer to my wife, took away the aforesaid motorcycle in the month of September 2022, my lord. More than 1.5 years back, my lord. Now, my lord, next page, my lord. But today, dated 19/6/2024, through phone number so and so, I am asked to pay the installment for the aforesaid motorcycle. Then I got surprised as I thought it was taken as an installment money is yet to be received. So, my lord, he defaulted in making installment payment of installment for a bike he purchased from our company. Then his bike was taken by the company in the month of September 2022. From the first part of the FIR, it is apparently clear, my lord, that he is not aggrieved by the fact of taking away the motorcycle because it was taken.
But you know where it is mentioned that if the motorcycle was taken away
in the month
because
of September.
because of non-payment of installments, not here.
I'm coming to that, my lord. This is 21 page number, my lord. But on today dated so and so, through phone number so and so, I'm asked to pay the installment for the aforesaid motorcycle. Then I got surprised as I thought it was taken as an installment money is yet to be received. So Assamese vernacular, my lord, if I may place, my lord, that my lordship will find that page 23, Assamese vernacular, it will become more clear, my lord. Page 23, my lord. My lord, page 22, last para, my lord, I'm sorry. 22 last para, my lord. কিন্তু আজি 19/6/2024 তারিখে সোয়েন্সো ফোন যুগে অধীনত উল্লেখিত মটৰ চাইকেলৰ কিস্তিৰ পৰিশোধ কৰিবলৈ কয় তেতিয়া অধীনে হতভম্ব হৈ পৰো যিহেতুকে কিস্তিৰ টকা পাব আছে বুলি নিয়া বুলি ভাবিছিলো So যিহেতু কিস্তিৰ টকা পাব আছে বুলি নিয়া বুলি ভাবিছিলো, that is why he was under an impression that the motorcycle was taken for non-payment of the installment amount, and that is why he has not initiated any proceeding way back in the year 2022. Only when he received a phone call from our company on 2024, he lost this SIR. My lord, instead of filing this SIR, he ought to have clarified the position before the company that his motorcycle has already been taken away. When I clarified to the company, my lord, company has said that company has already received the, my lord, payment, because that is the job of a, my lord, the collection, my lord, I am the collection manager. My job is to see, my lord, whether is there any default in payment of installment. And then, my lord, it is given to a third party, my lord, appointed by the company, who is a recovery agency, who recovers the bike, my lord, when certain my lord, default is there. And in this case, my lord, September 2022, because he defaulted in making payment, my lord, the recovery agency collected the bike, my lord. But he never filed any case because he was not aggrieved with the fact of recovery of the vehicle. Only when he received a phone call from our company, he filed this case, my lord. Now, my
If
lord,
you have taken away the motorcycle, why you have again, made a phone call?
Sometimes, my lord, company inadvertently calls, it may, my lord, call somebody that your installment is due. Then that is the subject matter of the purchaser
But as
to
per
clarify.
instruction from your client, at present the installment is already.
My lord, that I have inquired, my lord, and I was given a My lord, that is if actually the company who if files this case, my lord, it would have been a different aspect altogether, my lord. Last para, my lord. Last para. That there is no pending outstanding area amount against motorcycle bearing registration so and so as loan closed and NOC has been issued. So company has also clarified, my lord, this aspect that loan is closed, my lord, now, my lord. So inadvertently, someone might have called, my lord, from this number, my lord, that his payment is due, my lord. Immediately, he should have contacted the company and clarified the position that my bike has been taken away. But rather than doing that, he filed this as a harm, my lord. Their company is not a party to this case. Company has not filed any case, and company has not been made an accused by the informant also.
So case is still under investigation, I think.
No, my lord, that charge sheet is submitted, my lord.
Charge sheet is also
Proceeding
submitted.
initially. And that is why I am submitting, my lord, when under these facts and circumstances, it
Then
will get,
obviously during investigation, there might have been any inquiry.
my lord, please.
Then how charge sheet is filed? If
Charge
it
sheet,
is
my
your,
lord, page 30.
I mean, your submission is correct. If it is not
lord.
loan amount is there, then
My lord.
charge sheet is
Page
also.
30, my lord. 30. From 10 line, my lord.
Hmm.
10th line, my lord. In the month of September 2022, collection agency of Hero Finance, Sri Biju Paing returned back the bike as per order of finance manager, Sri Vishal Sahu, that is me, my lord, and promised to close the loan. On 19/6/2024, complainer got a phone call from Hero Finance, has told him that he has to pay installment amount of rupees so and so to Hero Finance. They did not close the loan of Sri Vishal Sahu, and Biju Paing sold the bike to one Mohammad Rafiq Ali. So that is the internal matter, my lord. After recovery of the bike, my lord, what the company do is the subject matter of the company, my lord. Here, under these facts and circumstances, if case is, my lord, allowed to be proceed, my lord, apparently it is an abuse of the process of the court, my lord, because company has clarified its stand that they have received, my lord, the loan amount. Nothing remains.
So why didn't you, this was not produced before the IO?
No, my lord, when I received summons, my lord, when I received summons, my lord, then I had to appear. Then I clarified the position before the company, because my job is not, I am not the recovery agency. I am an employee of the company, my lord. That, my lordship, may kindly come to page number 15. This is my appointment letter, my lord. I'm still working in this particular company as a collection manager, my lord. Page number 50 is my appointment letter, and page number 17 is my identity card. This is some communication that took place between a company and one purchaser, my lord. He is not aggrieved by the fact that his bike was taken because he has not paid the installment. And definitely he has stated in the FIR itself that he was under an impression that his bike was taken because he did not clear the installment, my lord. Then also, my lord, charge sheet has been submitted, my lord. And proceeding has been initiated, my lord, against me.
Yes,
That is why I am aggrieved.
Yes,
Since the matter has been surseated, Lordship, so we need the scanned copy of LCR. So without going through the records, it will be difficult for us to go through.
My lord,
Have
next
any-
date is fixed on 10th for consideration of charge, my lord. That is why I pray, my lord, because, my lord, unnecessarily
10 of
will,
January.
December, my lord. So
It can be
till
taken-
then, it may be state, my lord, till returnable date, my lord. Deeply obliged.
Mr.
Thank you, Das.
MK Das. Hard Mr. MK Das, the Direct Counsel for the Petitioner. And also hard SH Bora, the Direct Petitioner PP, appearing on behalf of state respondents. I feel he this is an application, so it's so. Issue notice to respond number 2 to study and as usual process. So call for this scan copy of DLCR. However, considering this submission made by the Direct Counsel for the petitioner, the further proceeding in connection with
PR case number 68, my lord, of 2024.
PR case number 68 of 2024, pending before the learned court of SDGM at Jonai Dhemaji, please still till next date of listing.
I'm deeply obliged. Highly obliged.
Lordship fixing any date?
No, this after 4 weeks.
After four.
After.
Outline.
28.
May please your lordship. Small issue lordship, this respondent number 2 lordship has initiated proceeding under domestic violence act. When this petitioner was made party as respondent number 1 and he appeared lordship. And his family, other family members also lordship made party in the said proceeding, they have also appeared. Since lordship, more than 1 year, the mother of the petitioner was suffering from severe lordship, cancer lordship. And finally, she died on 15th of November 24, last 15 months. And during this period, this petitioner was not in a position to appear in court, but his engaged counsel was representing him. On last lordship on 2024, 20th of September, none of the even the engaged counsel also not representing this petitioner. Accordingly, the cross-examination right to cross-examine the complainant was dispensed with us. So now case has been proceeded. My humble prayer is simple. 1 week may be time, 1 week time may be given. We will cross-examine the complainant.
Where is the order sheet?
Lord, you will find at page 36. Last page also, my page.
Please will firstly notice to go to respondent number 2.
So the monthly maintenance of
Lord,
rupees
yes,
10,000
yes.
is also not paid by you.
Not paid because of lordship mother's hospitalization lordship last 1 year.
See, but you
Yes.
have appeared before the Planning Court below, isn't it?
Yes,
And
yes.
to
And lordship, yes, lordship, we are now
This
lordship,
case
we are ready
notice
to
should go,
appear in the court also lordship and to lordship proceed the case. Lordship may give me 1 week time so that we can appear and lordship. On 15th of November, his mother has died lordship. After lordship, more than 1 year's hospitalization, she has died. So, lordship, considering that aspect, lordship may given a 1 week, 1 more time lordship.
Let them appear first, lordship.
It will, no issue lordship, but it will just delay the process lordship. Otherwise, nothing will happen lordship, even if they appear. I am not contesting on merit of the case lordship, just right to cross-examination lordship of this complaint cases. I'm not claiming, not even challenge the lordship mentioning.
so you are the only petitioner
Yes, the respondent husband lordship.
and the other respondents are already
Already
expired.
mother has already died lordship. Mother has also made party and she has died lordship on 15 November. And father and father and brothers.
So
Yes,
you are the R1.
R1, the husband. I have not challenged here anything lordship regarding quantum and maintenance and all lordship. Only to right to cross-examine lordship. If lordship you should notice lordship, it will just delay the process lordship. Otherwise, nothing will happen lordship. If lordship fixed date directing this petitioner to appear and lordship, the airport may be lordship directed to allow this
Now what is the next date?
on 3rd of December lordship. Yes, tomorrow lordship.
Fix it tomorrow.
Tomorrow perhaps lordship, as instructed my client.
It is again a formal party here, I think.
Formal party lordship.
That is why lordship.
Only 1 week time may be given lordship, we are ready to.
Why 1 week? Then tomorrow is there date
Yes.
fixed.
Or tomorrow, yes, lordship, yes. Lordship may direct tomorrow.
Are Mr. Chikalita, the learned counsel for the petition. Also have MSSH Pora, the learned additional PP appearing on behalf of state respondent number 1. Bagi likhib, this is an application. So against the mainly order of say 2009, 2024, passed by NCR DB case number so and so, filed by so and so. It is submitted by Mr. Kalika that the petitioner as a respondent number 1 could not appear before the learned trial court below for on several occasions only because of his illness of the mother, who was also one of the respondent in the said case, and was a patient of cancer, and ultimately, after being in and finally she ultimately she died on 15/11/2024. 24. As the petitioner and the other respondents had to be busy for her treatment, he was not in a position to appear before the learned trial court below. But at present he is ready and willing to appear before the learned trial court below and to contest the case accordingly. But full stop. But on 20/09/2024, the cross evidence of the PWs were dispensed with and cases fixed for final argument. If the case is heard ex parte, the petitioner will suffer from there will be prejudice caused to the petitioner, and hence prayed for one to give one more chance to appear before the learned trial court below and to cross-examine the PWs, and also prayed to allow the petitioner to adduce his evidence, if any. Post. Next para, after hearing the submission made by the MSSH para submitted in this regard, the petitioner may be directed to appear before the learned trial court below with a proper application which may be considered by the trial court below accordingly. Next para, hearing the submission made by the learned counsel for both sides and on perusal of the order passed in 20/09/2024, it is seen that detailed order has been passed by the learned trial court below, wherefrom it is seen that for last 10 days, the respondent number 1 / the present petitioner failed to appear before the learned trial court below and also did not pay any interim maintenance as directed. So considering his long absence, the order was passed and whereby the cross-examination of the PWs were dispensed with and the case was fixed for final argument. Thus, no illegality or irregularity has been committed by the learned trial court below while passing the order. However, for the ends of justice, I find that one more chance must be given to the present petitioner to cross-examine the PWs. Accordingly, the learned trial court below is hereby directed to give one more chance to the present petitioner, cross-examine the PWs. Against you, DWA is also issued, na?
This DW is lordship, I'm not sure whether this lordship DW or lordship defense witnesses, I'm not sure. Lordship?
No, it is
Yes,
distress
DWA.
warrant.
Yes,
Not
maybe
the-
lordship distance order, but that order I have not seen lordship, that's why I'm saying this. Distance.
Here only it is
Yes.
written.
It may be DW, distance warrant also.
So as it is submitted by learned counsel for the petition, the case is fixed tomorrow, that is on 3/12/2024 for final hearing. The petitioner is accordingly directed to appear before the learned trial court below and file an appropriate application for cross-examination of appropriate application and appear before the court below and will also proceed to cross-examine the PWs accordingly. Yes, sir. With the above observation, your sense. Okay, you will appear before the learned trial court below tomorrow. Cross-examine directing the learned trial court below to give you a chance for person.
One lordship might be problem lordship, if the certified copy of this order. Tomorrow lordship they may not receive because I have to get certified copy, I have to send,
Today only you can receive,
but
we'll pass the
I have to
order.
send it to Thugri lordship.
That I cannot say. That many excuses cannot be given.
Of the lordship, on that the lordship will seek adjournment stating the order.
You
Yes,
collect, you try
yes,
to
yes.
get the certificate copy today itself, true facts and all you can
Text I
send.
can send, but certified copy is original, it's not possible. Anyway,
It
lordship.
may not be there.
Yes, lordship.
Today everything is in
Lodge,
detail in
yes,
the
yes.
website only.
Lodge.
Oh.
Obliged.
May I please, your lordship? Yes. Lordship 528 BNSS application, your lordship. Due to not passing any effective order by your lordship, Session and District Judge Nagaon in a criminal appeal, your lordship 13/24, your lordship. What is the case, your lordship? In the one NIA complaint case has been filed, your lordship, against this instant petitioner, your lordship, before Chief Judicial Magistrate, your lordship, Nagaon. And the Chief Judicial Magistrate, your lordship, Nagaon filed order dated 28 February 2024. Pass an order, your lordship, sentencing the petitioner to pay 32 lakhs rupees, your lordship, with 6 months rigorous imprisonment. Now, against that, your lordship, agreed by which we have prepared that appeal, your lordship, that is criminal appeal number 13/24, before your lordship, Session and District Judge Nagaon, your lordship. Then that case has been fixed for 10 times, your lordship, since 28 March 2024, and the next date fixed for 7 December 2024. Now, admission, that case was fixed for admission hearing, your lordship. Now, lordship, in the criminal appeal, your lordship, neither my case has been rejected, your lordship, neither the case has been admitted, your lordship. Lordship may kindly come to page number 27, your lordship. First, it was fixed on 28 March 2024, your lordship. It is at page number, your lordship, 26, where we have paid for an adjournment, your lordship. Next date, your lordship, at 6/4/2024, your lordship. That is page number 27, your lordship. Here, your lordship, we had been advised to furnish some relevant copies from the lower court, your lordship. And lordship, we have furnished at the second paragraph, your lordship. We have directed to submit our response as to why I will not able to pay 20% of the check amount, your lordship, on the event of admitting the appeal, your lordship. Now, if your lordship kindly turn the page, and your lordship kindly come to page number 29, your lordship. It is 18/5/2024, your lordship. Here, your lordship, I have placed my submission that this case comes under exceptional circumstances for which I may be exempt to pay the 20% of the check amount, your lordship. Now, that prayer also not admitted, not rejected. And if your lordship kindly turn the page at page number 30, your lordship. Here, your lordship, I'm reading the relevant portion, your lordship. This may be considered as last opportunity to the appellant to deposit the amount, and the same has been granted after taking due note of the fact that the appellant has declined to deposit the same, which was much lesser than the said amount quantified today. Fixing 1/6/2024 for deposit of 20% of the fine amount and further hearing on admission and necessary order, your lordship. Now, on the very next day, your lordship, that is 1/6/2024, page number 31, your lordship. Here again, we have filed a petition, your lordship, praying for exempting me, lordship, for the payment of 20% of the check amount, your lordship. In this way, lordship, case has been fixed for necessary order, your lordship. Lordship may kindly see 19/6/2024, 12/7/2024, again 17/2024, your lordship. I place my submission that I am not in a position, your lordship, to pay the 20% of the quantum amount, your lordship, of the check amount, your lordship. Now, your lordship, but instead of passing an order, your lordship, the date has been fixed for necessary order, hearing, your lordship, for which, your lordship, my case, your lordship, which is pending before CJM, your lordship, which is pending for payment of arrear amount, your lordship. Adverse order has been passed, warrant of arrest has been passed, your lordship. Your lordship, here We are constantly, your lordship, praying, your lordship, that we are not in a position, your lordship, to pay. My grievance is not on the merit of the case, your lordship. It may be rejected, it may be admitted, your lordship. It is not my lordship submission. It may be rejected, your lordship. But on the event of rejection, your lordship, I would have remedy, your lordship. I have remedy to approach before this honorable court. But for that reason, your lordship, my lower court case is also going to be worst, your lordship. So the next date is fixed for 7 December 2024, your lordship, for necessary order and, your lordship, for order, your lordship. So my humble prayer, your lordship, in this occasion, your lordship may kindly give a direction, your lordship, to the honorable session and district judge, your lordship, to pass a effective order, your lordship. It may be admitted, your lordship, it may be rejected. That is not my submission before this honorable court, your lordship. This effective order may be passed, your lordship, on 7 December 2024. That is my case, your lordship.
We're listing it after 7th of December. Let's see what order is passed. List 7, 9 can be 11 December. List on 11. December.
Lordship, till date.
Report us when, yes, till then.
Lordship, with due respect, your lordship. Your lordship, till date, your lordship, the impune effect of that CZM orders may be stayed, your lordship.
11 December. List on 11 December. We are not going. What order, what kind of order passed? Just show us. Certificate copy. Certificate copy be furnished along with an additional affidavit.
Lordship, must not be.
30.
May I please, your lordship? This is an application under section 482 of BNS, your lordship. FIR is at page 14. The petitioner, your lordship, is an assistant teacher of high school, your lordship. Allegation under section 10 of POCSO, your lordship. Your lordship may kindly go through the FIR first. With dear respect, I beg to state that my eldest daughter, namely so and so, is a student of DB Milan High School, so and so. Presently, my daughter is facing trouble getting education due to lack of faith. On 18 November 2000, we were shocked when my daughter narrated few facts with anxiety and nervousness after returning home from the school. We have come to know that one teacher of the school has been harassing her by touching by a person body. On that day about 11:30, when along with 2 boys were in a classroom, then one teacher, namely Gulo Govinda Deka, and the private part teacher has repeatedly touched so and so. Perhaps she requested the teacher to abstain from doing so. It is pertinently mentioned that there's only guard present in the classroom, and besides her, there are 2 boys in the classroom. My daughter further told that it was done by the teacher sitting with so and so in the same bench. After coming to know, then your lordship, case was registered, and a complaint was also, your lordship, lodged before the school authorities, your lordship. And school authorities thereafter convened a meeting. Your lordship may kindly come to page 20.
20.
Your lordship. Your lordship may kindly come to the vernacular, your lordship. There is some problem with the translation. Page 24, your lordship. আজি 20/11/2000 তাৰিখে বুধবাৰে বিদ্যালয়ৰ সভাপতি যোগেন্দ্ৰ সভাপতিত্বত এখন কাৰ্যকৰী সভা অনুষ্ঠিত হয়। সভাৰ সদস্য সচিব প্ৰমোদ বৰ্মনে উদ্দেশ্য প্ৰকাশ কৰিছিল যোৱাকালি 19/11/2024 তাৰিখে আমাৰ বিদ্যালয়ৰ 7ম শ্ৰেণীৰ ছাত্ৰী দিয়া বড়ো মাতৃশ্ৰী বন্দনা বড়ো অভিভাৱিকাগৰাকীয়ে কেইগৰাকীমান মহিলাৰ লগত লৈ আহি কাৰ্যালয়ত অভিযোগ দিয়ে যে বিদ্যালয়ৰ সহকাৰী শিক্ষক গুণগোবিন্দ ডেকাই শিকোৱাৰ চলে তেখেতৰ ছোৱালীক অশালীন ব্যৱহাৰ কৰিছে। গতিকে এটা উচিত তদন্ত কৰি দৃষ্টান্তমূলক ব্যৱস্থা গ্ৰহণৰ মৌখিক আবেদন জনায়। লগে লগে প্ৰমোদ বৰ্মনে বিষয়টো জানিবলৈ বিচাৰে। তেতিয়া অভিভাৱিকা বন্দনা বৰুৱাই গোবিন্দ ডেকাক অভিযুক্ত বুলি উচ্চবাচ্য কৰে। আনকি বিষয়টো সুস্থিৰভাৱে আলোচনা কৰাৰ বিপৰীতে গুণগোবিন্দ প্ৰথমে হাতেৰে প্ৰহাৰ কৰে, আনকি হাতত চেণ্ডেল লৈ প্ৰহাৰ কৰিছে। তাৰপিছত পৰিস্থিতি খাম পতাত প্ৰমোদ বৰ্মনে আলোচনা কৰি অহাকালি বুধবাৰে 2 বজাত এছেম্বলি সভাপতিক আহ্বান কৰি এখন কাৰ্যকৰী সভা অনুষ্ঠিত কৰাৰ বিষয়টো বিশদভাৱে আলোচনা কৰে। যদি অভিযোগ সত্য বুলি প্ৰমাণিত হয় তেনেহলে দৃষ্টান্তমূলক ব্যৱস্থা গ্ৰহণৰ আশ্বাস দিছিলো। কিন্তু আজিৰ সভাখনলৈ আহিম বুলি আশ্বাস দি এই পৰ্যন্ত বন্দনা দাস বড়ো সভাত উপস্থিত হোৱা নাই। থুলমূলকৈ সভাৰ উদ্দেশ্য এইখিনিয়ে। দেন ইয়ৰ লৰ্ডশ্বিপ, সভাপতি গুণগোবিন্দ ডেকাই কয় যে সমিতিৰ চিত্ৰকৃতিত সহায় কৰাৰ কাৰ্য উত্থাপন কৰিছে, মানে ইয়াৰ কোনো বেয়া ধাৰণা নাছিল। সভাত আলোচনা কালত বিদ্যালয়ৰ 4ৰ্থ শ্ৰেণীৰ সহায়ক চিন্ময় বড়ুৱে বক্তব্য ৰাখি কয় যে তেওঁ বিষয়টো সত্যাসত্য নিৰূপণৰ ইচ্ছা কৰি সপ্তম শ্ৰেণীৰ ছাত্ৰী দিয়া বড়ো সহপাঠী সমৰ বড়ো আৰু পীযুষ কলিতা দুয়োজনৰ পৰা জানিব বিচাৰে। সমৰ বড়ো সেইদিনা শ্ৰেণীত উপস্থিত আছিল যদিও তেনেধৰণৰ কোনো অশালীন কাৰ্য আচৰণ দেখা পোৱা নাই বুলি ক'লে পীযুষ কলিতাই কোনো নজনা বুলি জনায়। Now this is the case, Your Lordship. Now ultimately, Your Lordship, I have made a statement, Your Lordship, that explanation that I have beaten her on that day, Your Lordship. Corporal punishment, I did not disclose because it is banned, Your Lordship. Now, at the end of the day, Your Lordship, that is the reason why this FIR has come. On the face of it, Your Lordship, a teacher among the students, I can understand if she is
No,
taking.
nowadays, so teachers are doing all this.
No,
We
no,
are
Your
getting lost many cases.
No, no, many cases.
In
No,
many
no,
cases
what
are
has
there
fallen from-
against the teachers only.
No, no, that is what I am submitting, Your
You
Lordship.
cannot say that teacher
No, no, no,
cannot
that
do
is
this.
not
That
teacher.
is teachers
I am
are
not
there
saying,
only.
I am not saying that, Your Lordship. What I am submitting, Your Lordship, in the classroom, they cannot do, Your Lordship. If it is
Even
taken
in
to
classroom,
somewhere
even
else.
in a private room, everywhere he is
And
doing
it is also a fact that these are the, Your Lordship, acts, Your Lordship, in
Certain
spite of its
things are there.
noble
Okay, we
objective,
are
Your
issuing
Lordship.
notice to the respondent number 2, issue
Yes.
notice for review. Also call for the case.
Your Lordship may fix a date, Your Lordship.
After vacation.
Maybe after vacation only, I guess.
That's the problem, Your Lordship. He
Prior
will have to.
vacation, I don't have any dates. In fact,
Since it will be for service only, Your Lordship.
On 18, Lordship.
Lordship.
it.
Obliged, Your Lordship.
58 of the supplementary list.
But not as long as the motion test.
May I please, Your Lordship? Yes. So as per the instructions, Lordship, we have filed the additional affidavit today, Lordship. Lordship, the matter may come up day after tomorrow, Lordship. Lordship,
Additional affidavit. you
yes,
have
Lordship, to bring on record the certified copy of the lower court records, Lordship, orders.
filed. You are Mr.
Amen.
Or Mr. Amena, you are responsible for the petition. It is submitted by and also heard by Mr. Enso. It is submitted by him that they have already filed the today, na?
Yes, Lordship.
They filed the additional affidavit today itself to bring some documents on record. Accordingly paid to release the matter. On Kino. Tomorrow is fourth, fourth of Science. Prayer list. Okay, we are listing it on fourth.
Timing 22.
22.
May I please, Your Lordship?
Oh,
I don't think there was a next. But in this, since we lot, for question we have, and before this court, that is on 4/8/2014, that's my learned friend, my lord. For the last 1 decade, my lord, the affair, the progress of the affair, the status of the affair may be directed to place before this court. Lordship may fix next date. My learned friend will get the information, what happened, but what updates that the 2014 affair, my lord. That is my submission.
the FIR is of 2014.
Yes, my lord, Lordship, page, annexure 2, page 15, my lord, 4/8/2014.
Yes. Well, it's a PS case, perhaps TP would be in a better position. I am for the excise department.
That is also true.
So PS case,
That is also
madam
true, my
can
lord.
bring matter.
Though they have filed, but PP is also concerned in this matter. PP may direct that, my lord.
Then what direction should be you want?
Madam, the status of the affair dated 4/8/2014, my lord, at present stage.
4/8/2014.
14, madam. In my lord,
Case number
PS,
1951.
yes, PS Silchar, PS case number 1951/2014.
Silchar PS case number
51
1951 of
2014. But that must be the status of this, present status of the case. Short date may be fixed. Lord.
The copy may be furnished to our company.
Yes, definitely. Already served, definitely I will.
Please, sir.
Today, tomorrow. Oh,
copy already furnished.
already furnished, then the extra copy I will furnish again.
We'll work it out in between.
Thank you.
So calling for the status report on.
Yes.
Lordship and fixing, my lord, short date, my lord, only for this report.
Short date, we don't have what to do. Otherwise, all will be leftover matters because there are no dates, in fact.
Then may I pray, my lord? I understand, my lord, lordship, I have seen, my lord. Can it be on, my lord, 10th of January? 10th of January.
It can be.
Yeah.
Deeply.
Always.
Regarding the involvement of the petition.
No.
No, I don't know. Status.
Is case charge sheeted or not? What happened to the PS case? That's
Whether
Yes.
investigation is completed or a search is being.
Actually,
Only that status.
yes.
Or you need any other case diary and all if it is needed.
Then we can place it the next case also. Whether search is filed or not, that report we can provide.
No, but thereafter there may be sufficient, so that's why I'm saying.
Not sure.
No, in that case, only status report you are going to submit or what? I don't know, just he is saying.
Status, along with the status report, all this will come, whether charge sheet has been filed or not, whether FR has been filed or not,
But
everything
in
will
that
be
case, that's what I'm asking, because suppose charge sheet may be there, charge sheet may not be there.
my lord,
That is different.
my lord.
But what is the material, if there is
progress-
any,
Progress of this affair, my lord, that much information. Yes.
only status?
Yes.
Okay, 10th of January. Okay, you state filed the status. As
10th
to
of-
whether this charge sheet has been filed or not.
Yes.
Charge sheet has been never and to progress and also to report regarding the status of the progress of the investigation.
Yes, my lord. Deeply obsessed.
what do we know?
For bill hearing, item 37.
ই বৰাকো হাত কৰি দি গগৈ হাত কৰি দিব আৰু SS বৰাক হাত কৰি দিব কিমান কৈছো
37.
May it please all of you. Oh, the other
37 yes 37
My lord, may it please all, my lord, here the case diary was called for, my lord.
yes sir we have received Mr.
No, here, my lord, only with all respect, my lord, if your lordship goes to the contents of the FIR, my lord, what happened in this case, my lord, the occurrence took place on 15/7, my lord. Lordship may kindly have a look at page 13, my lord. Specifically, my lord, from one vehicle, my lord. Lordship find, my lord, 4 persons, my lord. They were found in the vehicle, my lord, and they were arrested, my lord, page 13, my lord. Why I'm praying, my lord, because in spite of repeated reminders, my lord, the case diary is not being produced, my lord. So here, my lord, the petition accused persons, my lord, they are in custody for around, my lord, last more than 3.5 months, my lord. So page 13, definitely, my lord, case diary will be necessary, my lord, but only the background, my lord, I will be just in 2-3 minutes, my lord. But kindly see page 13, my lord, Lord should see, my lord, 4 persons were arrested, my lord, specifically, my lord, from one vehicle. And the seizure list also we have annexed, my lord. They also lordship find, my lord, from their position, my lord, that is the type copy at page 21, my lord. These 4 persons, they are named, my lord. So now, my lord, that occurred on, my lord, 15/7/24, my lord. The date, lordship, kindly see, my lord, top, my lord. Date and time of seizure, my lord. 15/7. Now, my lord, what happened, my lord? Immediately thereafter, my lord, lordship, kindly have a look at page 16, my lord. These 2 accused persons, my lord, along with, my lord, 4 others, they were arrested. In this case, my lord, where absolute recovery was made in day 1 from specifically 4 persons, my lord. Page 16, lordship find, my lord. So these 6 persons were arrested, my lord. We are, my lord, this petition has been filed for, my lord, number 1, my lord, and number 3, my lord. So, my lord, here at best or at worst, my lord, it can be a case of, my lord, statement of co-accused. That is also not reflected in the forwarding report of the persons, my lord, from whom the recoveries were made. That also we have annexed, my lord, at page 18 and 19, my lord. Because the first.
Why you could not produce the case diary in fact?
The case diary was called for, my lord.
Ah.
It was lying, my lord, before the landed session, just Punitpur, my lord. My lord, just cases pending.
You're from Sunitpur.
It's 3 hours time, my lord.
The case diary was lying, my lord, in the court of session, just Punitpur, my lord.
No.
Maybe, my lord, bail application is pending before the landed trial court, my lord.
But this case is also pending since
My lord,
for
first
production
order,
of case diary.
24/10, my lord, first order, my lord. Thereafter on 13/11, thereafter on 26/11, my lord.
It's 24/10.
Yes, my lord, that was the first order. Thereafter 13/11.
That instruction you have received from IO.
IO, my lord.
No, let him be personally present, my lord. Because this, my lord, kindly see, my lord, otherwise I would not have prayed, my lord, because no recovery.
at best or at worst maybe statement of corpus that has no value in the eye of law, my lord. And they are in custody, it will be 4 months, my lord, after a few days, my lord. So let the diary along with the IO be present before this court, because in spite of repeated reminders, my lord, they are not sending it before the High Court, my lord.
One more chance may be given, but it will come next Monday, my lord.
No, no, my lord, they are, it
Next
will be
Monday.
4 months, my lord. It will be 4 months by then, my lord.
That's why he is saying next Monday only.
Then kindly, my no, then, my lord, kindly Thursday or Friday from Tezpur itself, my lord. Friday, my lord.
Your purpose will not be served.
No, no, my
Thursday or
kind-
Friday may not come.
my lord, it's 3 hours time only, kindly.
Whatever, it may not come. We are seeing the question, so that's why.
Let us take a chance. but if
Next
possible-
Monday only.
If possible on Friday, if possible.
Not at all possible. You are Mr. Chaudhary.
Yes, ma'am.
Heard Mr. E. Chaudhary, the Land Council for so and so. Also heard Mr. R.J. Purva, the Land Traditional PP so and so. And it is submitted by Mr. Purva, the CD not received, and it is lying, and from the intimation received from the IO, it is lying before the Session Judge Sonitpur Tezpur. Post in that context, Mr. Chaudhary, the Learned Counsel for the petitioner, submitted that the petition is pending since 24/10/2024, and not 24 means 24. It was first called
First
for, I
call
think.
for, first call.
24, and on the two consecutive dates, the CD was called for, but in spite of the, but CD is not yet received. Moreover, further he submitted that the accused petitioners are behind the bar since last more than 3.5 months, and hence 3.5 months, and hence he submitted that the IO may be personal show cause notice may be issued to the IO for his personal appeals. Next paper, before issuing any personal show cause notice, etc., the IO is hereby directed to procure the CD from the Court of Learned Session Judge Sonitpur Tezpur and to produce the same on or before the next date of listing without fail. In default, he may be served with a personal show cause notice. List accordingly on Monday is what time? 9th 12th.
Much obliged, ma'am.
May it please your lordship. Lordship, this is an anticipated bail application, lordship. Before peruse that FIR, lordship, may I, lordship, peruse the page 18, that is the legal notice, lordship. Legal notice was served upon my, this is the informant is my second wife, lordship. Now actually dispute between my first wife and second wife, lordship. After having first wife, lordship, I have married this lady, lordship. That's why, lordship, she live in my house, lordship, and that legal notice will clear it, lordship. Can you peruse the page 18, lordship? The notice was sent on 23rd September, lordship. Sorry, lordship, it's July. When we send this notice subsequently, lordship, she filed this case, lordship, just to take a revenge because I have not, I have supporting my first wife, lordship. Although I have asked her to come, lordship, she has used her first daughter from earlier husband, lordship, in this
This
allegation.
legal notice was
Give-
sent by you.
Yes, lordship.
Why?
Because, lordship, I have married this lady, lordship. This
Whom?
informant, lordship. Present case informant, lordship. I married, lordship, having my first wife also, lordship. And this is, lordship, she left the house, lordship. Then, lordship, I sent a legal notice. That is on page 18.
To return back.
Lordship, that is, ask her to come back, lordship.
Achha.
On 23rd July, lordship, this notice was sent, lordship.
Notice served, my lord.
Then, lordship,
Huh?
Yes, it's served, my lord.
that notice, lordship, you find on page 18, lordship.
Yes.
Para 3, relevant portion on para 3 and 4 on page 19, lordship. That too, lordship. She repeatedly, lordship, without my permission, she left the house, lordship. Without, that's why, lordship, I've given her notice, lordship. When, lordship, after receiving this notice, lordship, on 29/7, just, lordship, 6 days later, she lost this FIR, that is on page 16, Lordship. Well draft, typed FIR, Lordship. When it's on typed FIR, Lordship, definitely, Lordship, expert hand is there, Lordship. That is on page 16, Lordship. Absolutely, Lordship, misusing the Lordship provisions of law, Lordship.
Today, my lord, we have not received the case diary, my lord. As far as my service is concerned, my lord, notice has been received by the my lord informant. It's a case of POCSO, my lord.
Also 10 is there, but Lordship has
Service is
found that
already, service is already complete.
Service complete, my lord.
So we are going to appoint.
My lord, sir, amicus may be appointed.
Till then, you are going to retain the case diary?
No, my lord, case diary is not received, my lord.
Case diary not
Not
received.
received, my lord.
just so I'm a family man, kindly protect Lordship because of her this Lordship concocted FIR, Lordship. I am on run, Lordship.
Now see, I have these such kind of things I have already dealt with. In fact, he is to, I may think maybe say father. Even by our own father also, this kind of things are going on. So how
Because-
can you say
Wow.
wrong,
So
right? I cannot say.
Yes,
But the
until
question
that,
is that
legal notice is not there, Lordship, I would not have submit these things, Lordship. Because we have sent a legal notice, Lordship. It's an outcome of this outburst of this, Lordship, legal notice, Lordship.
she is not interested to come back.
Yes, Lordship.
And then why she lost the FIR?
Because of Lordship, actually fighting between two wives, Lordship. For my first wife with this second wife, Lordship. After having this five, why should I marry her, Lordship? That's the problem, Lordship.
Okay, very nice. Heard Mr. B. Chaudhary, Tilane Contemporary Petition, also heard Mr. R.J. Purva, Tilane Traditional PP, appearing on behalf of State Respondent. From the office note, it is seen that the service is already completed on respondent number 2. However, one has represented her. Accordingly, it is found necessary to appoint an amicus curiae to represent the respondent number 2. The registry will do the needful in that regard. Further, issue reminder to call for the case diary, list accordingly. When it can be listed then?
10th of December. 10th.
It is on 10th December. 10-12. Okay, we're listing on 10-12.
In the meantime, Lordship, some protection, Lordship. I'm a family man, Lordship. Some
Such
protection.
allegations are there.
Because it says 10, Lordship, and 354A was 354A is available, Lordship. But 10 is just to make a case, Lordship, non-available.
10-12-14.
Highly obliged.
Yes, nice. I would yes. I would be less.
One more day.
Here also CD receipt.
CDs.
Item 50 CD. Item 50 CD receipt.
Item.
Oh, sorry, 59. You have received the CD?
Yes.
Well, then it will take some time. Who is the counsel, in fact? To ask him. You are there, na? At 2 we take.
My lord, one item 46 is there in your lordship's list. But there only service report is awaited, my lord. But the interim order is still today. So if your lordship kindly extends that.
46.
46.
The service report is still awaited.
Still awaited. And there is an interim order which is operative till today, my lord. If that can be extended until further order.
We'll extending it and you want to await till next date or want to take
Your
fresh
lordship,
steps?
your lordship, this registry report says that service report is awaited. Let us wait for some time.
Till next date.
Till next date.
Service be awaited till next date. Interim be continued till next date of listing. Okay. List accordingly after 2 weeks.
Your lordship, a date may be fixed, 20th of January, if that is
20.
20.
20 January. Okay, we are fixed.
Obliging.
Yes.
Malad, this is 483 BNSS application petitioner behind the bars for last more than um, a month, Lordship. 3110 he was arrested, yes. And in a similarly situated case, Lordship has already given the privilege of the arrest bail to the main accused, whose consignment was in transit, Lordship. This is the order, Lordship. And he was only the driver of that commercial business, Lordship. He was the only on his role is only to drive the vehicle, Lordship. That is he's neither the owner of the rice nor he's the owner of the vehicle, Lordship. He's only a driver. He was driving at the instruction of his both the owners. This petitioners, as well as because he is the owner of the rice and his master, vehicle's owner. So that is his only role in the entire case, Lordship. And that the truck was detained, Lordship, suspecting that it is PDS rice, and that was the sole reason of detention. And as there was some heat and this negligent driving on the part of the driver, and then he was apprehended in the case. And since for last he's a poor man, for more than a month he's detained.
So as per the FIR, my lord, when the truck was, my lord, intercepted, my lord, he could not produce any documents of the rice bag. This is why he was arrested, my lord. Now, bail order.
Bail order to dispute.
What is there? I don't know, my lord. At least, my lord, I'll only pay to call for the case.
Indeed.
Lordship, what is my prayer, Lordship? Because he has nothing to do with the business, Lordship. Lordship has already cited a detailed observation of the entire fact, Lordship, taking into account of the and even the forwarding report also says, Lordship, he has been detained to locate the owner of the rice. Forwarding report at page 11, Lordship.
Yes, my lord. In this case, my lord, this is my lord, what I have submitted, my lord. So as per the FIR also, my lord, documents could not be produced, my lord.
That is
This
so.
is the driver was arrested. And lordship granted interim, my lord, to this person, my lord, to appear before the IO and to produce the documents, my lord.
Where it is fixed, other one?
Otherwise, other case, my lord, 10-12.
But Lordship have considered my application.
Okay, then do one thing, as the earlier dated as per order reflects that most probably he produced some sort of document before the court, where I'm not on record, but before the police, or it was not with the driver at the time of arrest. That was the intention why the rice may not be the stolen one or hidden. That is my observation is also there. So let it fix on 20th then. Both the matters.
Lordship, it will not rest because entire this fact relates to the owner of the rice. He has nothing to do. He's a poor man. He was only driving the vehicle, Lordship. It's the only source of livelihood by driving the vehicle, Lordship. Considering length of detention a month behind, Lordship. 3110 he was arrested, and today 2nd of December, Lordship. Considering the length of detention, and EC Act 7 of EC Act is bailable. That is bailable, and the rest of the part are not. Since one has claimed the ownership of the rice, and the owner has come forward before this honorable court, preferring an anticipatory rule, and this honorable court, after taking into all accounts, Lordship has granted privilege to the main arrest, This man, poor man, is behind the bar, Lordship. My humble prayer, Lordship, he may be granted regular bail, that too after a month, Lordship.
I must assume the learned counsel for the petitioner. And also heard Mr. R.J. Burwa, the learned additional PP appearing on behalf of state respondent. Back in Likivo, this is an application on section so and so in connection with so and so. It is submitted by MS Som that the owner of the rice, which is alleged to have been seized from the truck driven by the present petitioner, is already granted with granted with the privilege of interim pre-arrest bail, considering the interim pre-arrest bail, considering the materials available in the case diagram. Further, she submitted that the present accused petitioner is the driver of the said truck, and neither he is the owner of the truck nor he claims the ownership of the rice, which was seized, alleging it to be stolen rice. He is in He is in custody since last more than month, and hence considering his length of detention, and also considering the fact that he is only a driver of this case, of the vehicle, he may be released on bail. Mr. Borwa, the learned additional PP, submitted in this regard that the owner of the rice is allowed to remain on interim pre-arrest bail only with a direction to cooperate the IO in further investigation of this case.
And madam, he claimed the ownership of the rice.
Yes. And accordingly, he submitted, and further he submitted that the driver could not produce any document at the time of his intercepting the vehicle and at the time of his apprehension. Well, Mr. Borwa accordingly insisted that case may be, CD may be called for to know the other facts of the case. Next para. Considering the submission made by the learned counsel for both sides and materials in the case record, and also considering the order passed by this court on so and so, find that further custodial interrogation in order copy to divorce. I find that further custodial interrogation of the present petitioner may not be necessary for the interest of the investigation. Allow for it. Where it is pending?
CCM Kamruk, Lordship.
It was order to mention for you. CGM Kamruk.
Yes, Lordship.
To the section of the CGM Kamruk. 2000 with 1 suit of black.
Applies, Lordship.
20,000 with 1 suit of black amount. Huh?
May I please, Your Lordship? This is 482 BNSS application, Lordship.
Yes.
Matter pertains to Lordship, the recovery of 15 numbers of cattle. According to seizure of the said 15 numbers of cattle, Lordship. The petitioner, Lordship, being the owner of the cattle, Lordship, he has approached the learned court below, filed a zimma application, Lordship. The said zimma was allowed, subject to the condition that the petitioner should have to appear before the IO with his document, Lordship. And after executing a bond of rupees 7 lakhs, the IO was directed to give zimma of the said cattle, Lordship. Second page, last portion of the order, Lordship. Property portion. Second page, last portion, later on, Lordship.
Yes.
Later on, Lordship. Married, Lordship. The petitioner, Abdaruddin Ahmed, the petitioner, Lordship, is represented. Report as called for has not been received. The learned counsel for the petitioner has submitted that he has the original receipt of purchasing, selling cattle, and hence zimma of the cattle may be allowed. The petitioner is directed to appear before the IO
along with all the relevant documents of the kettles after shifting of 15 numbers of kettles from Messrs. AD Associates, ward number so and so, Udan Bihar, Punjabi, to Northeast Frontier Foundation. Further, the IO, after verifying all the legal documents purchase of seized kettles, is directed to hand over the zimma of 15 numbers of seized kettle to its legal owner on execution of a bond of rupees 7 lakhs, if the same are not required for the purpose of investigation. Lordships, the learned court below has already directed the petitioner to appear before the IO lordship, and he has produced the original parcel receipt lordship, and the kettle was seized lordship from the grazing field lordship. While it was kept for the grazing purpose lordship, the kettle was seized from the grazing field lordship, not it was seized from the while he is transporting from somewhere else lordship.
In the FIR it is there.
Yes, lordship. FIR lawsuit and page 14 lawsuit. Made it the FIR lawsuit. Page 14 lawsuit. সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 29/10/2024 তাৰিখে পুৱতি নিশা প্ৰায় 2:15 বজাত এক গোপনীয়ভাৱে সংবাদ পোৱা যায় যে কিছুমান গৰু সৰবৰাহকাৰীয়ে অবৈধভাৱে ও চোৰাংভাৱে গৰু মেঘালয়লৈ সৰবৰাহ কৰি আছে। মতে সংবাদ পাই মাননীয় OC মহোদয়ে মোক লগত ASI টিকেন চন্দ্ৰ ডেকা আৰু ষ্টাফসহ বিহিত ব্যৱস্থা ল'বৰ বাবে নিৰ্দেশ দিয়াত আমি গৈ তপাতলি মিলনপুৰ জংঘল এলেকাত নাকা চেকিং ডিউটি কৰোঁ। সেই সময়তে কেইজনমান লোকে কিছু গৰু খেদি পাহাৰৰ সৰু ৰাস্তাদি নি আছিল। সেই সময়তে লোককেইজনে আমাক দেখা পাই পাহাৰৰ দিশে পলাই যায় আৰু আমি পাহাৰৰ এলেকাত ভালদৰে তালাচী কৰাত মুঠ 15টা গৰু উদ্ধাৰ কৰা হয়। উক্ত উদ্ধাৰকৃত গৰুসমূহ থানালৈ লৈ অনা হয়। পিছত জানিব পৰা যায় যে উক্ত গৰুসমূহ মেঘালয়লৈ লৈ কাছাইখানাত বিক্ৰী কৰাৰ উদ্দেশ্যে নি আছিল আৰু উক্ত গৰুসমূহ চুৰি কৰি অনা বুলি সন্দেহ হয়। FIR said that he has suspected stolen cattle lawsuit. Now the petitioner lawsuit is the owner of the cattle lawsuit. He has what is the original cattle purchase to learned court below lawsuit, and the learned court below has already directed the petitioner to appear before the IO with this document lawsuit. So
Yes.
the KJ was also called for lawsuit.
CD we have received lordship as per seizure list. And the 15 numbers of cattle has been found in abundant condition. And so far the CD is concerned, the record says nothing is, there is no whisper about the ownership of the cattle structure. And since my learned friend has already granted
This fine
zimma-
is, I mean, is, money, this, against this petitioner, any whisper is not there. I mean, he is a owner and all, these are not there. So what the materials have been collected? I mean,
Lordship, so far as the statement of the seizure witnesses are concerned, they have stated that found 15 numbers of cattle in abundant condition that has been
in an
seized.
abundant.
Yes, that has been duly seized by the IO.
But is there anything that those were found or, I mean, they were seized from possession of someone else or someone? No. At the time, the cows are found in abundant condition.
On seeing the police person towards them, those persons fled away from the spot. So that is different.
To my instruction, it was kept for the grazing purpose in the said place. Lawsuit. The cattle were kept for the grazing purpose. Lawsuit.
Yeah, otherwise, most probably, I don't know, some documents were furnished before the learned additional CGN, on the basis of which the zimma was granted.
Option no. It is up to 1811 option. So can we call for the lordship allows, we can produce the up-to-date CD lordship.
But most probably you could not furnish the receipts before the IO. is it?
Yes, Lawsuit, because
Till
the
now
not
he
came
could
with
not.
the lawsuit.
Yes. Other way also, along with the relevant documents, they may be appeared before the IO.
Yes, that is the order here.
Yes.
Heard Mr. T. Shutia, the learned counsel for the petition, and also heard MS S.H. Vora, the learned additional PP appearing for the state respondent. This is an application on section so and so in connection with so and so. Did you receive? There is the same hard put set. It is submitted by Mr. Chutia, the counsel for the petitioner, that the present accused petitioner is the genuine owner of the 15 numbers of catalysts which are being seized in connection with this case, suspected to be the stolen catalysts. But those catalysts were seized from a grazing field wherein the cows were grazing in the field and when they were seized by police. Mr. Chutia further submitted that he filed an zimma application before the learned additional CGM Kamrup M, and considering the original receipts which were produced before the learned court below, the zimma prayer was allowed with a direction to appear before the IO with the all the relevant oblique legal documents, receipts, etc. And the IO is accordingly directed to hand over the kettles after proper identification and verification of the documents. Mr. Chutia further submitted that he could not produce the original documents before the IO as there was an apprehension of as he was apprehending arrest in connection with this case. However, after receiving the zimma order from the learned additional seizure, he will appear before the IO with all relevant documents to establish his ownership and to get zimma of the kettles. Next para, MS Bora, the learned additional PP submitted in this regard that there is no whisper in the case diary regarding the claiming of ownership by the present petitioner. However, those kettles were seized from a field found in abandoned condition, but till that no one has appeared before the IO claiming their ownership. Considering the entire circumstances of this case, vis-a-vis the order of the learned additional CGM dated 21/11/2024, granting zimma of the seized kettles, I find that the petitioner may be given a chance to appear before the IO with all relevant documents and also to cooperate the IO in further investigation of this case. In view of above, I find it a fit case to extend the privilege of pre-arrest bail to the present accused petitioner. Direction to the DD. Okay, will be granted with the privilege of pre-arrest bail. Appear before the IO, all relevant documents and all within 10 days and cooperate with the.
Or she was given interim protection or?
No, finally it's post.
That is for admission item 31.
Let me do Well, case is this, my lord. The husband, I am for the wife. The husband, my lord, entered into second marriage. He is a government servant. So ultimately, my lord, the wife with 2 children filed a maintenance case before the court below. So maintenance case, he did not appear times and again. Ultimately, it was decided expiry. And it was ordered that he is to pay an amount of rupees 2,500 for the wife and for 2 minor children, 1,500 each, 3,000. So 5,500. Challenging that order, your lordship, they came before your lordship.
How many children? 1 children, 2 children.
No,
Two children.
So, my lord, your lordship passed an order.
They have challenged, made a
Order
challenge.
dated 19/3/2020.
19-3,
2020.
20.
Your lordship passed the order against the maintenance order. In the case report, my lord.
Where, in which page you have annexed the order?
My lord, that order, my lord, served to me, my lord. In the record, my lord, 19-3,
No,
2020.
no, page number, just tell us page number.
My lord, your lordship's order sheet.
You know?
19-3.
19-3, that's what we need to do. 19-3, 2020.
19-3, 2020.
2020. Ah.
2020.
Ah.
So by this order, my lord, records were called for, etc. And in last paragraph, my lord, husband was directed to pay 5,000 rupees in the meantime. So order is of 2 months, 4 years earlier. Now your lordship, that stay order is in operation. Now your lordship would be pleased to see. Your lordship pass an order dated 19-1-2022. 19-1-2022. By this order, your lordship directed the parties to submit assets and liabilities. Because, my lord, in Supreme Court case, my lord, that is decided that in type of cases that assets and liability is necessary. Now what happened, my lord? After that order, 2 years is elapsed. I have filed my assets and liabilities on 17-11-2022 itself. But till date, my lord, the revision petitioners, my lord, that husband did not file assets and liabilities. So, my lord, my humble submission before your lordship, by that impugned order, my lord, the court below, my lord, ordered 2 things. First is this, that 5,500 as maintenance, and there was a area maintenance, so 10,000 per month against the area maintenance. So your lordship state that order, that 10,000 rupees against the area. Now what happened, my lord? They are dealing the matter because they are very comfortable. Husband, being a government servant, he is very comfortable. The stay is there. So he is not filing assets and liabilities for 2 years. Now, my lord, my humble submission before your lordship, with 2 minor children, I have due amount of 10,000 per month to be deducted from his salary. That has been stayed. But taking that chance, my lord, 2 years, they are sitting over, they are not filing assets and liabilities. Today, my prayer will be before your lordship. They will be alert. Find your lordship vacate this stay order. Otherwise, they will sit over it. Because they are very comfortable. 5,000 is paid, 10,000 is stayed. So that is my humble prayer before you, subject to what my learned friend said.
Lordship, Lordship. Here, Lordship, first of all, my senior friend, Lordship, I do respect Lordship with him, Lordship. First part is the correct Lordship. That first, on expert was the first Lordship. Being I am a Lordship, police constable Lordship, so I have some difficulty, Lordship. I could not require the time Lordship, that's why it's an expert Lordship. Some amount is given Lordship. In that proceeding Lordship, what amount is given Lordship, actually that is not entitled by her Lordship. Because from the day of separation Lordship, I am regularly paying her Lordship. And that is also, she is admitted in her deposition Lordship. Yes, she is regularly paying me. So Lordship, even the Lordship, the trial court Lordship, without Lordship hearing me, that order was passed Lordship. So Lordship, I filed a petition Lordship to vacate that expert order Lordship. In that petition, I have explained the delay Lordship. And where Lordship, the court below Lordship, rejected my prayer, and in spite of that Lordship, added some amount Lordship, then given the whole amount, that is the whatever is entitled in the order sheet lordship. In that petition lordship, even I lordship submitted lordship, then one daughter lordship, she already got married lordship. So her part will be go lordship. She is entitled in the amount lordship after the marriage lordship. But that amount is also lordship added in the order sheet lordship. So lordship, these two aspects is there lordship. In first part lordship, the calculation lordship, there is rupees 2,08,500 lordship. That amount is illegal lordship for my concern because that amount is calculated lordship from the date of filing the complaint lordship. And in this period lordship, she already received the amount lordship. I paid regularly lordship. So lordship, I have placed before the court lordship, this is illegal lordship. At least lordship, whatever she already accepted lordship, that would be deducted from this amount lordship. And another part is the lordship, the girl lordship who already married lordship, her part cannot be lordship calculated in this order sheet lordship. So on that service lordship, the orders state lordship, state means this conditional state lordship. So I have directed to pay 5,000 lordship. That is extra. Actually, whatever lordship, now she is entitled lordship 4,000. Wife and one girl lordship, it will be lordship 4,000. But another court lordship directed me to pay 5,000 lordship, 1,000 extra lordship. I am paying regular lordship. So lordship, now my only humble prayer lordship, if the calculation lordship I have done lordship, if I calculate properly lordship, then she is not entitled this 2 lakhs lordship. Because she already admitted, she already lordship received me from me, and the daughter's part lordship, there's no extra lordship added here lordship. So if I deduct this all lordship, she will not entitled now anything more lordship. And my humble prayer lordship, whatever I am paying now extra amount 5,000 lordship, I am ready to pay this lordship as on today lordship and in future also lordship regularly lordship. Only just this amount lordship maybe lordship my prayer lordship, this amount may be lordship deducted from me lordship, and I will regularly pay this amount lordship. This is my humble prayer in this court also lordship. And so for this
But
lordship,
whether the area is for only daughter, the other area part is also there for the other the respondent
wife
as well
and-
as your wife and one more daughter is there.
yes, one more daughter is there. And
So
their
if
part
you
is lordship
deduct, suppose if you deduct the
2,500 from
1,000
one
also.
lordship and yes lordship.
No, if you deduct the 1,000 also from the area amount, but still there will be a quite a amount will be there. Then in that case also the area amount will be.
The area amount will not be there because now lordship I am paying extra amount lordship 1,000. That is one part lordship, and the girl, the daughter lordship, first daughter lordship, she got made in the 2019 lordship. And but while the court does part this order lordship, that part is also added here lordship. So calculation lordship, my calculation is there lordship. My senior friend has not calculated their lordship that how much if deductionist part is come lordship come to me, then how much he'll entitled lordship. That is the here lordship. Now lordship, so far my case is first party is there, case is expertise basis lordship. So if lordship please to vacate the expert order, that is one issue lordship. Otherwise lordship, if I say lordship is says that deduction part will be, I will give the calculation lordship and he may also give calculation lordship. Then how much will be deducted? Then after deduction lordship, whatever given I will pay lordship. And as of today, I am ready to pay lordship.
But you never raised this issue regarding the daughter's marriage.
I have raised lordship.
When?
Before the court below, while I filed the petition to vacate the expert order, then also I pleaded here lordship, their lordship. And there is also, he knows very well lordship that daughter is married. This is how again why she is claiming that part lordship. He cannot claim that. And now one part is that lordship, the essential liability part lordship. So for lordship, perhaps I am also misunderstanding here lordship. However, Supreme Court says lordship, this part may not be covered to the revision report lordship.
No, it covers.
Lordship, this order lordship, lordship just read that part lordship. Perhaps it is before the trial court lordship. Even the court also said lordship, this is maybe still one to win lordship, this order lordship. I will say. Yes, 27 is the law. This direction is the lordship. Here, column B, payment of interim maintenance lordship. Only regarding interim maintenance lordship, this passage direction is the lordship. Lordship got page 827 lordship. Column B. This mark is in the bottom lordship. Yes, the column B, lordship, payment of interim interest. In this column, lordship, this is written, lordship. The affidavit of disclosure of essential liability annexed as annexure 1, 2, and 3 of the judgment as may be applicable shall be filed by both the parties in all maintenance proceeding, including pending proceeding before the concerned family court, district court, magistrate court, as the case may be, throughout the country. So, lordship, before the lordship, there is the trial court, lordship, district court, family court, or lordship, magistrate court. So, lordship, this is given, lordship, regarding the determining the quantum of interim interest, lordship. Only this affidavit is necessary to determine the quantum of interim interest. Even
Otherwise, it is not necessary.
so my understanding is this, lordship. And if it is a revisional court, lordship, so it may be, lordship, may be submitted before the trial court, lordship.
So you have submitted before trial court
No, at that time, this was not there, lordship. At that time, it was not necessary.
at the time?
At that time, perhaps this argument was not passed,
Decision
lordship.
was not there.
Yeah, lordship.
No, now, but after the direction, have you finished? Rightly, wrongly, whatever, as per your submission. The
Yes.
court directed to appear, furnish you the SSL liabilities. Have
Yes,
you,
yes, yes, one second.
have you furnished?
So that is not done. That is, I
So
have,
after
I
lapse of the 2 years also, you have not furnished.
So that is lordship. Actually, I have done my part. I have prepared also, lordship. But he said that he is not getting leave, lordship. That's why he is not coming,
No,
lordship.
no, regarding the SSL liabilities.
There
Suppose
is-
if his SSL liabilities before this court or before the trial court also, they're, I mean, they very easy to assess the thing. And in that case, you can also bring your submission that is in regards to marriage of your daughter and all.
Yes, yes, sir. That I'll
But till now, you have not filed.
So, lordship, I have also requested, lordship. He says that I am not getting not leave. That's why, lordship. Otherwise, I have prepared this assessment liability affidavit, lordship. So, lordship, then, lordship, only a date and fixed, lordship. Within 1 week, lordship, I'll call him. Otherwise, I'll leave the case, lordship.
Otherwise, he is insisting for vacation of the order.
Yes, lordship. Only 1 week time, lordship. I'll pay him same last day, lordship. Last time, lordship. If he comes, lordship, my case is my affidavit is ready, lordship. I have prepared even I have prepared the affidavit, lordship. But he is not coming, lordship. He says that I'm not getting leave, lordship. That's all, lordship.
You have preferred the what?
If this is level, I have prepared, lordship. That's agreed.
You already prepared?
Yes, lordship, I have prepared, lordship.
Acha.
But he's not getting time to, lordship, sign this affidavit, lordship. So on date will fix, lordship, within 1 week, lordship, I'll advise him, lordship. Otherwise, lordship, I will leave the case. But date will fix, lordship. Otherwise, lordship, if date not fixed,
Now
lordship,
see,
then-
because in 19(1) order, it's clarified that both the parties directed to submit the detailed affidavit indicating therein their financial status and also their liabilities and change of circumstances. These are also mentioned there.
Yes,
So as you have raised the issue that your one daughter already got married,
lordship. Yes.
so that the order is reflect itself that this change of circumstances, if any, that can also be intimated to the
So
court. But
that
you have
also
not.
benefit to me, lordship. Yes, that also benefit to me, lordship. Yes.
Yes, what?
Yes, lordship. One date may fix, lordship. Otherwise, lordship,
But,
it will not come back proper time.
Only thing is this, my lord, husband is in the habit of harass the wife. I humbly submit before your lordship. Because, my lord, taking many pleas, he did not appear before the court below. That is why expurgative order was passed.
Obviously.
And thereafter, my lord, they challenge this. They know very well that we can challenge. They came to challenge in 2020. And now, in 2020, this honorable court passed an interim order. So, see, I'm repeating this, that she is comfortable.
No,
So
that-
assets and liability.
But he
No,
is
no.
getting
My-
more money, lordship. He is
No, no,
already
no, my
entered,
lord.
he is getting more money, lordship.
My lord, my
That
lord.
I am paying
My
regular.
lord, let me submit, if necessary, my learned friend will submit. Let me complete. Now, what happened, my lord? He is making some calculation before your lordship. Is it the forum to calculate this? You challenge the expurgative order. Either this honorable court vacate the expurgative order or allow the dismiss your petition. That much. Assets and liabilities, 2 years, they are not filing because only behavior of the husband is this, delayed the matter. Harassed her like anything. Supposing one daughter enter into marriage. They should brought on record for 2 years back, that option has been given to the husband. But husband is sitting over the matter. Now he is hesitating without record that one wife or one daughter entered into marriage.
Where is the problem to bring it on record? He's not taking, and now again time is short. And what type of person? He is not a gazetted officer, a simple constable. That not that he is to come from Delhi and get this. He prepared it. Now he said that it is prepared, but it is not vetted. What type of behavior this? He is in the next district to Kamrup working. He could not come to sign this.
Now he is in Upper Assam.
Upper Assam, Lower Assam.
Whatever may be, but whatever
What-
amount
what
he is
is the-
getting, that there is
my-
extra
my-
amount. Even I am
my
getting the extra
humble
amount.
submission,
No,
Planet friend, when I am submitting, don't disturb. My humble submission before your lordship is this. From the very beginning, husband is behaving like this. He is in Upper Assam, sometimes in Lower Assam. From Upper Assam, he cannot come. Being a constable, he cannot take leave. That I am to sworn an affidavit before the High Court. Where is the officer? Will not grant him permission to go. But matter is this, delay it. Delay it inordinately. Anyhow, my lord, he is praying for time. Last chance may be given. 1 week time may be granted. Let him come and sign it. This should not be. It is a maintenance
By
matter.
Mr. Asok, 31, the learned counsel for the petition, and so Mr. M.A. the learned counsel appearing for the respondent. It is it is submitted by Mr. Sheikh, the learned counsel for the respondent, that this case is pending since 2020, and by order dated 19/3/2020, the petitioner was directed to pay rupees 5,000 per month, and the operation of order dated 31/10/2019, directing for deduction of the salary from the account of the petitioner was suspended till returnable date. Though after the ex parte order, the petitioner was directed to pay rupees 10,000, including the arrear amount. But as it was stated by this court, by order dated 19/3/2020, the the respondent is receiving only 5,000 per month, and the arrear amount is still accumulating. Further, he submitted that on 19/1/2022, an order was passed directing both the parties to submit their assets and liability statements and liability statements, and then in person to that order, the respondent had already submitted her assets and liability statement, but till that, even after a lapse of more than 2 years, the petitioner has not filed his assets and liability statement before this court. In this context, Mr. Hawk, the learned counsel for the petitioner, submitted that the assets and liability statement is ready, but due to personal inconvenience of the petitioner who stays in Upper Assam presently, could not come and sign on the affidavit. Accordingly, his part of order, he submitted that there's a change of circumstances, and the daughter of the present petitioner and respondent one daughter of the present petitioner and respondent already got married. But the suppressing the fact, the order of maintenance was obtained by the respondent. However, he sought 1 week time to file the assets and liability statements of the petitioner. Prayer allowed. This the matter accordingly on.
Another liberty will give a lordship to file a reply lordship. He has lordship, sir, every his assignment lordship, he is separate many fact lordship, I reply lordship. That liberty also will get granted.
There is no provision.
No, therefore, that's
If
why.
he suppress, you file your affidavit. How can we direct him?
Lordship, liberty will get, otherwise lordship.
What kind of liberty?
To file reply lordship. Otherwise, he says that there is no provision to file reply lordship. But he's suppressing there, he's suppressed many things there, lordship.
No, that can be.
Yes,
that
in my
can be
part, I will do
mentioned in
lordship,
the
but in her
rights
part,
and
lordship,
liabilities itself.
whatever she is lordship,
But
suppressed
there is
lordship, I have to
no
reply.
such provision, madam, that he will file reply against me.
Yes, then there's.
Reply to your assets and
Yes,
liabilities.
yes,
Eh,
lordship.
No, my lord, reply to my assets and liabilities.
No, there's no provision.
There
You
is no
cannot.
But
provision.
lordship, then.
You
lordship,
bring all these in your assets and liabilities.
Yes,
that I
he
can
can,
do.
he can state many things.
You cannot file reply.
Yes.
How can you?
Yes.
Bring all this to in your assets and liabilities. Don't make any reply. If 1 week, obviously after vacation it will come, otherwise. Or after vacation only it will come.
Not after vacation. Before vacation, today is
Before
3
vacation.
only.
Before
Three
vacation
only.
may not be possible,
Madam,
but not many messages.
anyhow, madam, January, up to January 3, there is vacation. 3 will be reopening there. It may be 4, 5 like this.
4, 1?
4.
4, 1? 4, 1. List on 4, 1.
The only thing is this, my lord, it should be last chance, online. Otherwise, my lord, he will take another plea.
তাতে এটা লাইন এড কৰি দিব আগতে মিষ্টাৰ শেখৰ এডমিশ্যনত এটা লাইন এড কৰিব they gave further break for vacation of the stay order তাতে দি থৈ দিব we'll see to it.
Last chance, one sentence, my lord, because my lord,
Let us see.
some pressure is necessary, otherwise he'll take another.
Otherwise we'll vacate the order.
My lord. My lord.
22.
Not with this criminal petition against the judgment of the Lordship's learned session judge passed in criminal division, Lordship. What happened in the case, Lordship? The petitioner, Lordship, filed a Lordship complaint before the executive magistrate, Lordship. And thereafter, Lordship, an inquiry was conducted by the executive magistrate, Lordship. On the basis of this inquiry, Lordship, page 16, Lordship, the executive magistrate passed an interlocutory order. Lordship, page 16. Lordship, the last paragraph, Lordship. Hence, considering the urgent situation, I am satisfied to draw up a proceeding under section 33 of CrPC against the second party member and OC of Paslam is directed to remove the obstruction, if any, created by the second party member from the scheduled path and ask the second party member to appear before the court and file WS as to why the order shall not be made absolute, and also direct to the OC concerned to maintain peace and tranquility in the locality and execute the order after observing all formalities and report compliance before the next date fixed. So thereafter, Lordship, the respondents without appearing before the trial court, they approach to the session court, Lordship, by way of a criminal revision, Lordship. And they filed the criminal revisions. Thereafter, Lordship, the impugned judgment was passed by the Lordship session judge. Page 33, Lordship.
33.
Page, sorry, 23, Lordship. And in this judgment, Lordship, paragraph, Lordship, 9, page 26. Page 26, may I read, Lordship? Ongoing through the impugned order, it appears that the impugned order is an ex parte order and the same was passed without hearing the revision petition. The primary question regarding existence of disputed path is to be determined by the learned trial court, and the said fact can also be considered after recording the evidence of the party. The claim of the parties is that the order of removal of alleged obstruction is required to be decided by the trial court after giving opportunity to both the parties. What appears from the impugned order is that the learned trial court passed ex parte order and directed the revision petitioner to file objection. As such, the impugned order appears to be interlocutory order
and the question of making the order of immobile obstruction is yet to be passed. Lordship, the learned, thereafter, Lordship, observing this, Lordship, it is an interrogatory order, Lordship. The learned session judge set aside this trial court order. Whereas, Lordship, the learned session judge has no power as per section, Lordship, 397 of 2 of CrPC, Lordship. He has no
Which is provision you are saying?
Lordship, section 397, CrPC, Lordship. 397. This side 97, one is the Marital, calling for records to exercise powers of revision. 1. The High Court or any session judge may call for and examine the record of any proceeding before any inferior criminal courts situated within its or his local jurisdiction for the purpose of satisfying itself or himself as to the correctness, legality, and probability of any finding, sentence, or order recorded or passed, and as to the regularity of any proceedings of such inferior court, and may, when called for records, direct that the execution of any sentence or order be suspended, and if the accused is in confinement, that he be released on bail or on his own bond pending. 2, my lord. The petition, the powers of revision conferred by subsection 1 shall not be exercised in relation to any interlocutory order passed in any appeal, inquiry, trial, or other proceeding. So, by this section, Lordship, this revision petition was not, Lordship, Lordship, maintainable. In spite of that, Lordship, the revision petition was entertained and passed the impugned judgment, Lordship. This is my humble submission. Therefore, Lordship, the judgment passed by the line of session judge is liable to be set aside, Lordship, upholding the order of the trial court.
That's it. Well, in this case, my lord, petition was filed under section 133 of CrPC, my lord. But the learned trial court, my lord, did not follow the provision of this section, my lord. First of all, my lord, this kind of order cannot be passed, my lord, because provision is very much clear. As per this provision, my lord, sometimes, my lord, what happened, my lord, even they recognize, my lord, public, my lord, government road also. Some, my lord, insane people may, my lord, block this road also. Under such circumstances, my lord, this kind of order may be there. But in this case, my lord, there is no such situation. And even then, my lord, the procedure under section 133 is not followed. Kindly with the provision. In
No,
this
what you're saying, it's not
133.
maintainable before the magistrate.
Magistrate is maintainable, but procedure is, my lord, different. How
Defective
this
procedure.
Procedure, my lord. As per this section, my lord, procedure is that, my lord, he has to pass order and ask me to, my lord, execute this order. And if, my lord, I, my lord, defy, my lord, their contention that their path is enclosed or it is their path, then, my lord, this matter may be, my lord, referred to the civil court, my lord. But here in this case, my lord, without hearing the, my lord, other side, my lord, simply on the, my lord, complaint, my lord, directly order is passed, my lord, and it is directed to the OC to, my lord, remove the, my lord, alleged, my lord, obstacle. That means, my lord, to remove the fence of my house, my lord. They are alleging that, my lord, this is.
So quashing of the order passed by the magistrate, you don't have any objection.
My lord, I am supporting this order, and I am, my lord, against that order, my lord. I am supporting the order of the, my lord, district judge, my lord, session judge, my lord. Session judge, my lord, rightly passed the order. He, my lord, held that, my lord, this kind of order is not permissible without hearing us, my lord. That is original respondent of the case, my lord.
No,
I am supporting my revisional order.
no, he is saying that he was not heard, and you are saying that you are not heard.
No,
He is
my lord.
not heard.
No, my lord. He is saying that, my lord, revisional court passed the order
without jurisdiction.
Revisional court, my lord, passed the order, my lord, without jurisdiction. saying that, my lord, original order which was passed in his favor was
in
not,
his
my-
favor.
his favor, my lord, was not, my lord, passed hearing me, my lord. And lordship,
Without hearing you.
yes, my lord. My lord, lordship, kindly, my lord, consider, my lord, pragmatic situation. My lord, one road, my lord, allegedly, my lord, I have encroached, my lord, my fencing, my house boundary is there, my lord. And one person, my lord, filed one complaint. And my executive magistrate, my lord, that too, my lord, simply directed the OC that you go and remove the, my lord, this obstacle, which, my lord, directly affect my lord, legal right to property, my lord. Therefore, my lord, this procedure under section 133, my lord, very, my lord, specifically provide, my lord, how to execute this, tackle this situation, my lord. He has to pass order, that kind of order, and he has to, my lord, shockos me to answer, my lord, why I should not, my lord, execute this order. And if I, my lord, can show, my lord, any cogent, my lord, evidence before the court, magistrate, my lord, that it is not, this is the case, it is my land and it is a private dispute, then magistrate will, my lord, refer the matter or, my lord, advise the party to go to the civil court. Here, my lord, he directly passed the order to the police. You go and remove my house, my lord, boundary and give them, my lord, a list path, my lord, which directly affects, my lord, my right to property, my lord, my legal right, which is also, my lord, is, my lord, settled principle of law. That kind of order, my lord, your lordship may not treat it, my lord, it is an interlocutory order. Because this honorable court, my lord, long time back, my lord, it is already held that when any order is passed by the any judge or magistrate, my lord, affecting the substantial right of any party, my lord, that should be, my lord, treated as, my lord, judgment, not, my lord, interlocutory order. What is exactly happened in my case, my lord, where, my lord, executive magistrate simply on receipt of the, my lord, complaint from a, my lord, outsider, he passed the order directing the OC to remove the, my lord, fencing of my house, my lord. Lordship, kindly avail this provision how to deal with this application, my lord, section 133 of the CrPC, my lord. May I read, my lord? When a district magistrate or a subdivisional magistrate or any other executive magistrate specially empowered in this behalf by the state government or receiving the report of a police officer or other information and on taking such evidence, if any, as he thinks fit, considers. My lord, these are the situation laid down, my lord. What may be in the complaint, my lord? A, B, C, D, E, F, my lord. Then such magistrate may make a conditional order requiring the person, that is me, my lord, causing such obstruction or nuisance or carry on such trade or occupation or keeping any such goods or merchandise or owing possession or controlling such building, tent, structure, substance, tank, well, as excavation or owing or possessing such animals or trees within a time limit to be fixed in the order. So, my lord, he has to ask me, my lord, require me to remove such obstruction or nuisance or to desist from so and so, my lord. These are the, my lord, as per his problem, my lord, I encroach the road, my lord, path, village path, my lord. Then, my lord, or, my lord, this is important, or if he, that is I, my lord, if he objects so to do, to appear before him or some other executive magistrate subordinate to him at a time and place to be fixed by the order and show cause in the manner herein provided, why the order should not be made absolute. No order duly made by the magistrate under this section shall be called in question in any civil court. Now, my lord, lordship, kindly will look procedure. page, section, my lord, 137. It is, my lord, provided a procedure where existence of public right is denied. Where an order is made under section 133 for the purpose of preventing, obstructing, nuisance or danger to the public in the use of any way, river, canal, or place to magistrate shall on the appearance before him of the person against whom the order was made, question him as to, he has to question me, my lord, as to whether he denies the existence of any public right in respect of the way, river, canal, or place, and if he does so, the magistrate shall, before proceeding under section 138, that is to absolute the order, my lord, inquire into the matter. If in such inquiry magistrate finds that there is any reliable evidence in support of such denial, he shall stay the proceeding until the matter of the existence of the such right has been decided by the competent court. So, my lord, he has to, my lord, pass this order and ask me to appear before him why I should not remove this alleged obstruction. And if I, my lord, deny and I satisfy the learned magistrate that this is my right or this is my place, and if magistrate is satisfied, my lord, then, my lord, this matter may be released for, my lord, to the both the parties to approach the competent court, my lord. Or otherwise, he will proceed to, my lord, execute his order. But this mandatory procedure is not followed. In this case, my lord, I beg to refer, my lord, some judgment. All, my lord, I beg to refer the judgment of this honorable court, my lord, 1991, 1 GLR, page 28, my lord. In this regard, my lord, short paragraph, my lord, 11 and 12 may be relevant, my lord. Para 11, in view of the above discussion, there are interlocutory order which can be called or regarded as judgment, considering the meaning of judgment stated above. In other words, every interlocutory order cannot be regarded as a judgment, but only that order would be or would be regarded as judgment which decides the matter of moment affecting or matter of moment, lordship, affecting the valuable right of the parties, or the interlocutory order which contains traits and trapping of finality, either when the order decides the question for controversy in the main proceeding or ancillary proceeding or in a part of the proceeding. Therefore, there are two kinds of interlocutory orders, one which would be regarded as judgment and other which would be regarded as a judgment. Would not be regarded as judgment and another is regarded as judgment. So, while in this case, my lordship, kindly have a, my lord, pragmatic view in the situation. When, my lord, my boundary wall they are disputing, then, my lord, it is I have enclosed their part, my village part, and he directly taken the order and magistrate directed the OC to remove it. So this order cannot be treated as a, my lord, interlocutory order, because, my lord, once, my lord, my land is gone to the public path, my lord, village path, my lord, I will not able to, my lord, recover this again, my lord, without going for any title suit, my lord. Then, my lord, another, my lord, judgment, my lord, it is, my lord, 2003 Criminal Law Journal 2634, my lord. Paragraph 27, my lord. Married, my lord. Paragraph 27 of this judgment, my lord, provides that depending on the circumstances, the court is entitled to issue conditional ex parte order as per provision of section 133 of 1, my lord, and as per the provision of section 134 of the CrPC. Service or notification of the order is to be made in case of urgency. Magistrate is authorized to pass an order of injunction pending inquiry as per section 142 of CrPC. Upon service of notification of the order, person against whom such order is made shall either obey or so cause as per the provisions of section 135 of the CrPC, and if the person does not appear, the order is made absolute, and in appropriate case for violation of such order, he is liable under section 188 of the Indian Penal Code as per the provision of section 136 of the CrPC. If on receipt, this is important, if on receipt of such order or notification he appears and show cause against the order, then the magistrate shall, on the appearance before him or the person against whom the order was made, first question him as to whether he denies the existence of public right. And if the answer is in the affirmative, it is for him to adduce evidence, and if upon inquiry the magistrate finds that there is reliable evidence in support of such evidence, he shall stay the proceeding until the matter of the existence of such right has been decided by a competent court, and if he finds that there is no such evidence, he shall proceed as per the provision of section 138 of the CrPC, or in other words, if it is decided by the magistrate that the claim is not well founded, the evidence is taken and the conditional order is made absolute, or the proceedings are dropped in appropriate case. If the order is made absolute after the inquiry, the magistrate may proceed to enforce it as enjoined in section 141 of the CrPC. But here, in the particular case, looking into the materials available specially from the order dated so and so, it appears to me that the learned magistrate, on the appearance of the OP, that is the petitioner herein, never question him whether he denies the existence of public right in the pathway or not. Instead of doing that, he proceeded to inquire into the matter and passed conditional order, placing reliance on report of the video trial obtained in connection with another case without awaiting for the report called by him from the OC so and so. That being the position, upon assessing the available materials, I am prompted to hold that the findings that the procedure adopted by the learned magistrate in connection with the present proceeding under section 133 of the CrPC was absolutely wrong in law, and it was violates the ratio laid down aforesaid two decisions supra. Accordingly, the order passed by the learned magistrate making order under section 133 of the Code of Criminal Procedure, precisely the order dated so and so, cannot at all sustain, and the same therefore needs to be set aside. So, this case exactly, my lord, matching with the present case, my lord. Here, my lord, no chance was next, my lord, paragraph 14, I beg to refer in the judgment 2007 Criminal Law Journal 136, my lord. I beg to, my lord, refer paragraph 14. In this case, my lord, paragraph 14, my lord, right hand side, my lord, to cut short, my lord, that dispute between, my lord, I am from middle, my lord, after 14 lines, my lord. That dispute between both the parties, my lord. under paragraph 14, my lord, right hand side, my lord. May I read, my lord? The dispute between both the parties was a private dispute, and to settle such dispute, the provision under section could not have been invoked. The dispute raised by the said respondent as against the petitioner and other was in nature of a private dispute, and it could not be enforced by a action in a civil court. The provision of section 133(1)(a) are not meant to settle private rights which have no public character. Section 133 of the code can be resorted to only in the interest of public and not to be made a substitute for litigation in civil court in order to secure settlement of private dispute which do not affect the members of the public in general. The said respondents have been agitating a right to access to their house through the property of Bhaktagar, which was obstructed by the petitioner and other, and in such a situation, their remedy was elsewhere and certainly not in the proceeding under section 132 of the code. Now, exactly in this case also, my lord, they are, my lord, claiming that this is a village path, my lord, and they, without this path, my lord, they cannot, my lord, they go to the main public road. Now, lordship, kindly another judgment, my lord, I beg to refer. This is my lord 1986 Criminal Law Journal 102, my lord, paragraph 4. Section 133 of the code, my lord, authorize the magistrate to make a conditional order requiring the person causing obstruction or nuisance or enumerated in the clause.
Here is also dispute is for one part only. One part you have already obstructed the part.
According to them, my lord. Actually not so, my lord. It is, my lord, sometimes what happen, my lord, some village people take government money to in the name of path, my lord. It happens, my lord, in the rural area. And they want to, my lord, they grab this money, my lord, or exploit this money, my lord, forcefully they, my lord, they want to show, my lord, there is a path to take money from the government, which is exactly happen. Otherwise, my lord, in a public court, my lord, they are ordinary people, how they cannot, my lord. Only to show public work, my lord, local small contractor, my lord, and take money. They try to, my lord, they to show the measurement, exact measurement to the department. My this is size wise, this money comes, my lord. They forcefully trying to, my lord, enlarge this path, my lord, towards my house.
My lord.
1 or 2 feet like that, my lord. And in this case, my lord, their petition is also clear that there is a path, their personal path, my lord. Without this path, they cannot touch this, my lord, the main road. Even otherwise, my lord, the procedure, my lord, actually legal aspect is that, my lord, the procedure which is, my lord.
So they have that easementary right.
They are claiming like that, my lord. But procedure, my lord, over and above, my lord, the procedure which is adopted by the, my lord, magistrate is not at all, my lord, as well. He has to pass this order and ask me, you do this or remove this your thing. But then there may be my valuable things also. This is main fundamental principle of this kind of code is that, my lord. Suppose I have given kept some valuable things even encroaching the road, my lord. Therefore, he has to give me first chance to me, so that, my lord, this cannot be, my lord, destroyed, my lord, or damaged. If I deny, my lord, it is not enforced, my lord, and magistrate is satisfied, my lord, he may advise us you go to civil court. And if, my lord, he is not satisfied, then he may accordingly proceed and even forcefully.
Okay.
My lord, may I submit? Lordship, this is not the case here, lordship, that whether the trial court's order is right or wrong. My lordship, submission is there, lordship, but case is that the order passed by the revision court, the session court, whether it is maintainable or not. This is my case. And the revisional court passed the judgment without its jurisdiction. I have Lordship. This is my main case, Lordship. As my learned friend has said that the trial court's procedure, Lordship, for a moment, Lordship, as per section 133, Lordship, the magistrate has the power to pass conditional order on receiving the report of police officer. At here, Lordship, page 15, I have annexed the report of the police, Lordship. May I read, Lordship? Submission of report. I have the honor to report that I am locally and physically inquired about the fact of the petition submitted by first party members so and so, so and so, so and so. During report, it is came to know that an old path, broad, so and so, is situated near the PWD road at Kalinagar, part 6, opposite the public pond, and this path is only means for communication of locality and for the student who studied at 412 number so and so school. There is no other alternative way for communication of the people of said locality. During inquiry, it is seen that the second party member, namely so and so, his other family members have digged land of the said path, and there is possibility of occupying the land with newly building illegally. Furthermore, they are blocked the said path recently with cut pieces of trees, planted betel nut and banana trees on the path, for which village and students are facing much difficulties and troubles to communicate with this path. It is also learned that 1 inch land of this path was purchased from the father of second party, and 5 feet land of this path was purchased from Nipen Das of on so and so, and this path was improved under NREGS scheme in the year 2007 and 2009 and 2020 respectively, as approved work as per work order. So it is transparent from the inquiry that second party member have illegally blocked the public path, and this blocked of path should be immediately cleared up. This is the police report, my lord. On the basis of this police report, the trial court passed the order, lordship, and this order is conditional, allowing them to appear. If they have any objection, they may appear. Kindly see for the moment, lordship, the last paragraph, lordship. Hence, considering the urgent situation, I am satisfied to draw up a proceeding under section so and so against an OC of so and so is directed to remove the obstruction if any erect by the second party. If any erect by the second party member from the said path, and ask second party member to appear before the court and file W as to why the order should not be made absolute. So they have given a chance, lordship, as per the order, as per the section 33, lordship, procedural, lordship, what my learned friend is saying, that there is a procedure, the procedure has already been followed, and without approaching to the trial court, submitting their objection, they approach to the alternative way, lordship, and this alternative way, lordship, they file, lordship, the revision petition, which is not actually maintainable as per the law, lordship, and this revision petition was entertaining and subsequently set aside the trial court's order without jurisdiction, lordship, as per section 3972 of CrPC, lordship. So here, lordship, I am challenging this sessions court judgment, lordship. So this judgment is totally and the session court himself, lordship, at paragraph 9 of his judgment, lordship, observed that this trial court's order is interlocutory order. Paragraph 9, lordship, he himself, lordship, observed this thing, lordship, and after observing that it is an interlocutory order, he passed this impugned order, lordship. So it is totally, lordship, against the procedural, lordship, and established law, lordship. So this judgment is liable to be set aside, upholding the trial court's order. This is my humble submission, lordship. And whether if there is any objection, if they have any problem, lordship, they may go to the lordship trial court and submit their objection, lordship. That's my lordship.
It's okay, I have heard you.
Obliged.
সময় না সেই করে থাকা হিসাব করে it will be reserved Apache.
Obliged.
Yes, sir. Hmm, 33, madam. Madam, this criminal petition is in file, madam. Here, madam, this under section 311, madam. Complainant was allowed to, my lord, produce some document. After, my lord, recording my statement under section 313 and my written statement also given under section 313 by 313/4. In that case, my lord, here in the complaint, my lord, it is already stated that he has given the, my lord, this ledger and all. Ledger is already submitted in the, my lord, in his, my lord, in his evidence, my lord. Lordship will find at page 32. Evidence of the complainant. At page 62, my lord. Exhibit 6 and 6.1 are the ledger account of the supply of goods on credit of the accused by the complainant.
You are submitting the 32 is page number 32 are the documents.
Page number 32, my lord. Lordship will find at his evidence, my lord. Complainant's evidence.
These documents, mentioning about these documents.
Yes.
Complaint evidence is at page?
At page 32, Lordship will find at serial number 6, my lord.
Yes.
Exhibit 6 and 6.1 are the ledger account of the supply of goods on credit of the accused by the complainant. This is a, my lord, dispute between them is, my lord, under NI Act. This and then, my lord, this evidence in his cross-examination, my lord. When it is, my lord, put to him that it is a lordship will find at page 34. Last but one paragraph, my lord. It is a fact that in exhibit 6 and 6.1, there is no signature of accused assist doctor showing that he received the item as mentioned in the aforementioned exhibits. Then, my lord, our ledger is maintained in a bound register. I have not yet submitted the original ledger registers in this case. On the basis of this, my lord, they have filed one application under section, my lord, 311, my lord. That he may be allowed to, my lord, produce this register, my lord. And also here the prayer that some witnesses are to be examined, but that was rejected, my lord. If we come to, my lord, his evidence as well as in the complaint, my lord. Nowhere we find, my lord, about this, my lord, that there is some register he has maintained, my lord. When, my lord, we have cross-examined, my lord, he has come with the fact that there is a register and he want to produce them. When we have disclosed our, my lord, defense, my lord. My lord, under section 311, my lord, at any stage, my lord, as your lordship knows, my lord, witnesses may be allowed to be examined for the just decision of the case, my lord, as per provision of 311. But here, my lord, prosecution, they want to fill up the lacuna, my lord. Yeah, I am sorry, my lord. Prosecution means, my lord, complainant, my lord. He wants to fill up some lacuna in the case. Whether, my lord, that is, my lord, admissible or not, my lord. After coming to know our defense, my lord, he has filed this application under section 311, my lord. Three 311, your lordship know very well, my lord, that court may at any stage of any inquiry trial or other proceeding under this code summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall or re-examine any persons already examined, and the court shall summon and examine or recall or re-examine any such person if his evidence appears it to be essential for the just decision of the case. So this, my lord, this LCR was also called for, my lord. So this document, this copies of evidence, scanned copy of evidence, etc., those were also called. So I have also annexed with my lord, petition, my lord. So whether, my lord, it is for fill up of the lacuna or for just of the decision of the case, like. So I rely, my lord, to decision one of citation. One is, my lord, our Guwahati High Court, my lord. 2008 1 GLT 1093. Gopal Junjunwala versus Subrat Teja Chaudhary and another. 2008 1 GLT 1093. And another, my lord, of the Bombay High Court, my lord. Niketan Dilip Palde versus State of Maharashtra. Here also, my lord, after this cross-examination of witnesses, my lord, this application was filed. That was not allowed, madam. That is Bombay High Court judgment, madam. Hello. Hello. Relying on these two decisions and one of the principle of Milo 311, whether Milo complainant or the prosecution will be allowed at a belated stage, Milo, to fill up the lacuna or not. Only after Milo cross-examination, when we have put to him, Milo, he stated in the Milo cross-examination that he has got a bound razor, he wants to produce that, Milo. While filing the complaint, Milo, no whisper, Milo. He has exhibit 6 and 6.1, my lord. Then deposition also, my lord, while deposing before the court, there was no whisper, my lord. So only after our cross-examination, my lord, whether that could be allowed or not. This is my submission before release. No. No.
My lord, this application under 482, in fact, is a second revision in the garb of an 482 application, because their first revision was dismissed by the Honorable Sessions Court, and thereafter they're filing this. This is a second revision, my lord. And my lord, there is an embargo for filing second revision. Your lordship is aware, my lord, 397 subsection 2. The powers of revision conferred by subsection 1 shall not be exercised in relation to any subsection 3. If any application under section has been made by any person, either to the High Court or to the session judge, no further application by the same person shall be entertained by the other of them. Now, my lord, in fact, in the post title, my lord,
this application is also filed both under 482 and under 397. Now, my lord, to whatever little I understand, my lord, if there is a specific provision, my lord, then inherent power cannot be invoked. So if I say that there is a specific provision under 397, the provision for revision, then 482, these are not compatible sections, my lord. So this is one. Second, my lord, as far as the contention that under 311, my lord, the power under 311, my lord, as far as the facts are concerned, my lord, my senior friend on the other side have presently explained the facts, my lord. What happened is a check that almost around 30 lakhs check of 2020, my lord. The date of the check was of the year 2020. And till now, the case is lingering on one or the other pretext, my lord. They will file this application, that application. This is happening, my lord. Now, my lord, whether the order passed by the learned Chief Judicial Magistrate suffers from any infirmity, my lord, or whether that order is in tandem with the mandate of section 311, my lord. My lord, may kindly come to that order, my lord, because the order which they have essayed. Yes, that is at page number 45. But my lord, the relevant part is, these are all submissions from page 45, my lord. I'll skip all this. The relevant part, your lordship, my lord, may kindly come to page number 49. That's the observation or the finding of the court below. Now, my lord, in Rajendra Prasad versus Narcotic Cell reported in such and such 6 SCC page 110, I have carefully gone through this judgment. In this case, the Honorable Apex Court dealt with the question what is meant by lacuna in a prosecution case and laid down as follows. Lacuna in the prosecution must be understood as the inherent weakness or a latent wedge in the matrix of the prosecution case. The advantage of it should normally go to the accused in the trial of the case, but an oversight in the management of the prosecution cannot be treated as irreparable lacuna. No party in a trial can be foreclosed from correcting errors. If proper evidence was not adduced or a relevant material was not brought on record due to any inadvertence, the court should be magnanimous in permitting such mistake to be rectified. After all, function of the criminal court is administration of criminal justice and not to count errors committed by the parties or to find out and declare who among the parties performed better. Now, this is the other judgment quoted by the learned court below, and the finding is at page number 52. These are the judgment, page 52. I'm just skipping, my lord, because the watch is also ticking faster, my lord. Page 52. That's the finding. Now it's a page 52, my lord. There's the finding. In this is a case involving dishonor of check of a huge amount of rupees 29,86,600, and during cross-examination of the complainant, it came to the light that many documents relating to the transaction between the complainant and the accused was not adduced by the complainant as evidence, which he could have adduced and which is necessary to properly appreciate the facts of this case and to arrive at a just and proper decision in this case, and that the document submitted by the complainant along with the above petition comes within such category of documents. In view of the above and in view of the law shown by the Honorable Apex Court as pointed out above, I am of the considered view that without bringing such document on record, it will not be possible to arrive at a just and proper decision in this case, and hence in the interest of justice, just decision of this case, in exercise of the power under 311 of the CrPC, I deem it fit and proper to allow the prayer of the complainant to recall PW1. My lord, no new witness has been allowed. PW1. To recall PW1 and to allow him to adduce the documents accompanying the above petition as further evidence. Now, my lord, the trial court, my lord, while appreciating the evidence, my lord, is of the view that those documents are required for just decision. The power is under 311. Where is the manifest error committed by the trial judge? She has the power. It is a discretionary power. It is left to him that if you think that it is required for the just decision of the case, prayer was made to adduce further evidence in the nature of examining some more witnesses. She said, no, I will not allow more witnesses. As far as PW1 is concerned, fine, since you have mentioned regarding some documents which is in your possession, law mandates that inadvertent mistake can be corrected, and that will not tantamount to filling up lacunas, my lord. That is what precisely that learned trial judge has quoted that judgment, my lord, that would not tantamount to filling lacunas, my lord. Inadvertence, mistake, and that gentleman who has already been examined, and my lord, how they are prejudiced. It is not that whatever I will come and say will, without cross-examination, will be admitted in evidence. They will get ample opportunity to cross-examine me. I come up with something fabricated, they can cross me, my lord. They are not prejudiced in any case, my lord. This is why, now, my lord, then they challenge this order before the learned session judge under 397, my lord. Now, my lord, as a proposition of law, my lord, to whatever little I understand, my lord, a second revision under 397 or 482 is maintainable in rare of the rarest cases. There is a judgment, my lord. I'll give that small list of judgments, my lord. The scope of 482 itself is very limited. Now, here is a 482 petition which is against an order of a revisionary court, making the scope further, my lord, further narrowed down the scope. Now, my lord, the finding of the learned session judge, revisionary court, my lord, may kindly come to page 58. I'll skip all those, my lord, submissions made by either side and all these things. Page 58. My lord, the para which starts with section 311. Section 311 CrPC says that any court may, at any stage of any inquiry, trial, or other proceeding under this code, summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined. And the court shall, my lord, I take a pause here. The legislature now, my lord, this is a positive, my lord, positive direction, my lord. It is saying the court shall summon and examine or recall and re-examine any such person if his evidence appears to be essential to the just decision of the case. So, in fact, the legislature has deliberately used the word shall, because in certain circumstances, my lord, it shall be the duty of the judge to recall a witness. The object underlining 311 of CrPC is that there may not be failure of justice on account of mistake of either party in bringing the valuable evidence on record or leaving ambiguity in the statements of the witnesses examined from either side. The determinative factor is whether it is essential to the just decision of the case. The section 311 CrPC is not limited only to the benefit of the accused, it will not be an improper exercise of power of the court to summon a witness under the section merely because the evidence supports the case of the prosecution and not that of the accused. The Honorable Supreme Court in such and such has held that in the said case, it was further observed that the section is wholly discretionary. The second part of the section imposes upon a magistrate an obligation. That is what that shall part, my lord. It is that the court shall summon and examine all persons whose evidence appear to be essential to the just decision of the case. It is a cardinal rule of evidence that the best available evidence should be brought before the court. From perusal of the case record, it appears that during his cross-examination, PW1 stated as follows: our ledger is maintained in a bound register. I have not yet submitted the original ledger register. From perusal of the petition, and the Firisti dated such and such, it appears that complainant submitted the prayer for his re-examination in order to prove the ledger account of the complainant firm in favor of firm of the accused, TDS forms of the complainant firm and tax invoices of the complainant firm in favor of the accused firm. All those documents relate to past transaction in between the complainant and the accused. The admitted fact is that there was business transaction in between the complainant and the accused. In the course of trial, the complainant inadvertently did not exhibit the said documents, but subsequently it came to the notice of the complainant, while those facts were challenged in the cross-examination. Now, my lord, these are the findings, and ultimately, my lord, the revision petition was dismissed, and the order passed by the learned magistrate was upheld. Only few paragraphs I'll indicate, my lord. My lord, may only take the judgment at serial number 3, 5, 6, and 7. I'm only relying on this 3, 5, 6, and 7. Rest, my lord, while making the compilation, it somehow came out 3, 5, 6, and 7. Now for this 3, 2006 7 SCC 529, para 15 and 16, which your lordship will find in internal page number 49 and 50. 49 and 50. I have paginated this, my lord. 49.
Yes.
49. My lord, may kindly para 15 and para 16. I'm relying on these two paragraphs.
Yes.
I'll not read, my lord, because the time, because only para 15 I'll read, my lord. A conspectus of authorities referred to above would show that the principle is well settled that the exercise of power under 311 CrPC should be resorted to only with the object of finding out the truth or obtaining proper proof of such fact, which led to a just and correct decision of the case, this being the primary duty of the criminal court. Calling a witness or recalling a witness already examined for the purpose of finding out the truth in order to enable the court to arrive at the just decision of the case cannot be dubbed as filling in a lacuna in the prosecution case. It cannot be dubbed as, unless the fact and circumstance of the case make it apparent that the exercise of power by the court would result in causing serious prejudice to the accused, resulting in miscarriage of justice. In this case, no prejudice is caused to them. No new witness is coming. The same witness whom they have cross-examined, he just want to adduce the ledger accounts and some TDS forms. My lord, they want to cross, they can cross it. And para 16, my lord, para 16, normally the investigating agency cannot visualize. Now, my lord, this is important. Para 16, because one point they have argued that once the defense is exposed, now we are filing this application to fill up lacuna. That proposition, my lord, has been dealt with by the Supreme Court is in this case itself, para 16, the line which start with normally. Normally, the investigating agency cannot visualize at that stage what will be the nature of the defense. In fact, this is a justification given. Supreme Court is saying after cross-examination, then only what defense people are taking, the other side will come to know. In that event, my lord, if they want that there is some more evidence, they can do it. Rather, the justification of the Supreme Court is saying. Because at the stage of filing a charge sheet or at the initial stage, my lord, it is difficult to visualize what sort of defense would be taken. So based on the defense, a party can, in appropriate cases, adduce evidence. That's precisely the, my lord, that is what the Honorable Apex Court has held here. As the said stage comes after the entire prosecution evidence has been recorded, the prosecution is only required to establish his case by leading oral and oral. My lord, rest of the part I am skipping, my lord, for the an application moved by the this being the normal situation, an application moved by the prosecution for summoning a witness under 311 CrPC after the defense evidence has been recorded should not be branded as an attempt by the prosecution to fill in a lacuna. Only after closure of the evidence if they file, it should not be branded as an attempt to fill up the lacuna. Squarely covering my case now. Then the other judgment which I am relying was 1999 6 SCC, that is serial number 5. my lord may kindly come to the relevant paragraphs 7, 8 and 9. Page 89 and 90 are the relevant paragraphs. 89 and 90. Yes. Para 7, 8 and 9. 7. It is a common experience in criminal court that defense counsel would raise objection whenever court exercises power under 311 of the code or under 165 of the Evidence Act by saying that the court would not fill the lacuna in the prosecution case. The same ground was taken in this case also. A lacuna in a prosecution case is not to be equated with the fallout of an oversight committed by a public prosecutor during trial, either in proceeding relevant materials, producing relevant materials, or in eliciting relevant answer from witness. The adage to err is human is the recognition of the possibility of making mistake to which humans are prone. A corollary to any such laches or mistake during conducting of a case cannot be understood as a lacuna which a court cannot fill up. Same case, my lord, here it is not a public prosecutor, but a private counsel is prosecuting. Your lordship, we can have an analogy had it been an offense against the state, my lord, in the other typical cases. Right. Lacuna in a prosecution must be understood as the inherent weakness or a latent wedge in the matrix of the prosecution case. The advantage of it should normally go to the accused in the trial of the case. But an oversight in the management of the prosecution cannot be. Well, this paragraph already I have read, my lord, while reading the judgment. Yes, para 9 of this. It is therefore clear, well, the apex court, by quoting another judgment, they think it is therefore clear that the criminal court has ample power to summon any person as a witness or recall and re-examine any person, even if the evidence on both sides is closed, and the jurisdiction of the court must obviously be dictated by exigencies of the situation, and fair play and good sense appear to be the only safeguards, and that only the requirement of justice command the examination. So, my lord, closing of evidence cannot be a ground to totally bar recalling of evidence, because the mandate is at any stage, the only guiding factor is justice. Here is a case, my lord, he says that it is my ledgers are there in the boundary. 30 lakhs checks from 2020. The signature is admitted. Everything is admitted. He says, allow me to, along with some other witness. Trial judge says, he was fair to both the sides. He said, no, you don't bring new witnesses. Only yourself you can come. That they are making it. And the last judgment, this is para 9, which I'm relying. Yes. Raj, though, page number 100, internal page number 100. Yeah, para 9. Yes, my lord, the same principle, my lord. Same principle, even if it is closed, my lord, 311 can be invoked, my lord. I'll not repeat it, my lord. And the last one is page number 132. Page number 132. Page 132, para 27, my lord. The same, that on account of mistake of a party in bringing valuable evidence on record or leaving ambiguity. Rest are where, my lord, I am, because the same principle are written. My lord. This, my lord, because there is a concurrent finding by both the they can cross-examine my witness number 1. And moreover, my lord, this is a second revision. Yes, my lord, technically it is maintainable under 482, there is a decision, but the scope is very, very narrow. Unless there is an error apparent on the page of the record, in perimeter with the my lord principles of review jurisdiction. Apparent on the error apparent, my lord. Otherwise, my lord, the normal rule is that a second revision is not maintainable, not even in the garb of 482 petition. In that regard also, there are two Supreme Court decisions. But however, my lord, there are authorities which says in extreme cases, this can be. Now, whether they could make out such an extreme case, my lord, whether the court below, both the trial court and the revisional court had committed such an error that it calls for a order in a second revision or not. So that's my case, my lord. I'm grateful.
Well, that Prabhu Chawla judgment, 2016, 16 SCC. Page 30,
Yes,
madam.
2000, yes, Prabhu Chawla is with me also.
2000.
Please repeat.
I haven't got that judgment today.
No, anyway, you repeat please.
2016, 16 SCC, page 30. Prabhu Chawla's case, my lord.
Yes, yes.
In that case, my lord, that whether, my lord, that application under section 482/397 would be, my lord, applicable or not, my lord.
Yes,
It's a three judges bench of the, my lord, Supreme Court.
That's what he is also saying, that in some, there are some authorities where.
That is there, my lord.
I am also giving a judgment
but
that it is maintainable.
Whether, my lord, in a
1997.
complaint case, my lord. Complainant knows, my lord, whether the, my lord, his document is there. Earlier point from the very beginning, he knows, my lord. While, my lord, adducing evidence also, my lord, he has, my lord, produced some ledger. Subsequently, my lord, cross-examination, when it has come, my lord, he told that there is a big ledger is there, we are going to produce it, my lord. Whether that will be, my lord, allowed or not, my lord. And this, my lord, Bombay High Court decision and our High Court decision, my lord. Because only on cross-examination it has come, my lord. That is what, my lord, Bombay High Court says. This is my humble submission before your lordship.
Judgment to save or
Civil. Reason why the book matter karam tapar.
Your lordship has fixed it for judgment, my lord.
Orders. Order.
Okay.
delivery.
Obliged.
I am deeply obliged, my lord.
May I please your lordship. Lordship, I have challenged the impugned judgment and order dated 26/9/2024, which is page number 14, lordship. Lordship. Note. Yes. Lordship. Yes, lordship. Notice has to be.
Notice may be issued, but an appeal may be admitted and LCR may be closed.
It's not I, Lordship. Criminal activity.
Yeah, I have to file person, you're gonna file. If you're gonna file person. Suspension of sentence.
Yes. Then in that case also we are issuing notice, both the matter. Conviction under which section?
Section 3. Section 6 of POCSO, Lordship.
6 of POCSO.
Conviction under section 506 of IPC, Lordship. And
Term of conviction given.
4 of POCSO, Lordship.
Term of conviction is
10 years, Lordship.
কিন্তু admit করে দিও, issue notice করে দিব. There are two private respondents, 2 and 3. Issue notice. আৰু এইটো appeal is admitted for hearing. And in suspension of sentence also issue notice. That is after 4 weeks, we release. They also call for DLC. List after 4 weeks. Listing it after 4 weeks, take steps for the respondent number 2, calling for the LC and appeal is admitted.
55.
May it please your lordship. This is a criminal appeal against acquittal. Lordship, so far as the criminal leave petition is concerned, in the leave petition, no notices were issued on the respondent. So I believe at this stage, LCR.
No,
to be
leave
called for
petition
an-
wasn't. Why it is not listed here?
Leave was granted, lordship.
Or leave
Date
was
of petition,
granted
Yes, yes.
So you have to issue notice.
Issue then LCR may be called for.
Respondent 1, only 1.
Respondent 1, lordship acquittal under section 138 of negotiable.
138
instruments. Yes, lordship. Otherwise, the issuance of check as well as the signature is admitted. So the burden was upon him the respondent to
So
disprove.
what was the ground for acquittal?
Grounds
Otherwise,
that non-compliance of section 141 of negotiable instruments act. Although the check was issued in personal capacity, but then the company, since the goods were provided to the company, so non-issuance of notice to the company, that was the ground.
oh,
Otherwise, it's a settled law, lordship.
leave to grant is a leave to grant or have over like with leave to already grant is a appeal to admit করে দিব. Issue notice করে দিব to the respondent. Also call for this. That's take steps for the
We'll
respondent.
take steps. Deeply obliged.
36.
Please, your lord. This is an appeal against acquittal, madam.
Leave is already granted.
Leave is already granted. But the respondent didn't appear in the leave petition.
Was appearing.
Not appear.
Not
Though notice was served, he was not appeared.
But still, for formality's sake, you have to issue notice.
Lord,
Yeah, so because this is appeal against acquittal. in fact.
Appeal against
So they are the necessary party. no? So how many respondents are there?
State is formal.
State is formal. This is also NI.
NI, my lord.
Right. Appeal admit crop, issue notice. Mr. Reddy, no formal notice is required to be served on respondent number 2. Call for the LC. List accordingly after 4 days. Take steps on respondent number 2. We are admitting the appeal
Within a week.
within a week.
Thank you.
Here's a prayer for now. Of the lady working. This lady. Yes. She's still there. Let's see. Let's see. এটা পুনর্জন একটু জানি। Yes. এটা বহুত disturb লাগে। She is not here to. Any matter now, I'm getting there.
Upgraded. Item 48.
Further, petition file under section 430 method, witness method, granting of bail of the accused person method. I have submitted the certified copy method. As per judgment method, kindly see the judgment method, page 20. Annexure 2 method. That is the stated as per judgment method. Accused person petitioner is convicted under section 304 part 2 4 years and 10,000 amount is life penalty. As per judgment method, it is stated that page 26 method. Carefully perusal the above section.
Yes, you are appearing here, na? Who is appearing here? Yep.
My lord, already appeal is admitted. I have today is fixed for IA, my lord. Already co-accused Vishwajit Das, he is allowed to go on bail, my lord, on order dated 14/11/2024. Order pass. Already I have annexure 4, my lord. Annexure 4, page 117.
Mr. Borua, now on that day also, she was insisting that one co-accused was already. Now, bench should be a same bench or what?
Same fact, my lord. Same case, same fact, same allegation.
That can be done, my lord. She will place the matter before the same bench, my lord.
No, my lord.
Today, LCR has not come, my lord.
LCR not come?
Not come, my lord.
My certificate copy already I have provided, my lord. The learned
On
person.
21/11, appeal admitted, lordship has called for the case diary. Sorry, my lord, LCR, my lord.
LCR.
So LCR has not come, my lord. But he is insisting that, my lord, the co-accused has been granted bail on the, my lord, same day when the appeal was admitted, my lord.
But in that case, a record has already come.
No.
No, my lord. On the motion is this.
On the motion is this, my lord, she is submitting, my lord.
They are released on bail. Same fact, my lord. And you see the judgment, my lord.
Otherwise, what will happen? Once appeal will be here and the other will be suppose in other bench.
Yes, sir.
Then the LCR will be one only.
Yes.
So should be taken together, I think. Otherwise, after at the time of hearing of the appeal, it may be an opposition to say.
But hardly really allowed to bail, my lord, pending the appeal, my lord, pending the LCR. Already, co-accused is released on bail. It is the prejudice, my lord. As
Only
per my
ground co-accused is religion cannot
No,
be, may not
my
be,
lord,
or should
my
not
lord,
be the
judge-
ground. I
ju-
don't think so.
My lord, judgment is passed only for 2 eyewitness, my lord. One is Sondon Deka. Kindly see the
You
judgment, my
can,
lord.
you're ready? Then we'll hear the matter.
Sondon
He has
Deka and
furnished-
Vikarjit Das, my lord.
Yes,
He the
furnished, my lord, these are the, my lord,
No, she has already
evidence.
filed some certificate copy.
certificate copy. Sondon
Certificate
Deka.
copies are there.
Vikarjit Das, my lord. As per Sondon Deka, my lord, his evidence is that, my lord. IO is 13 witnesses are examined, my lord. As per medical report, PW1, my lord, medical officer, he stated that, page 77, my lord. Opinion of the cause of death. Opinion of regarding cause of death keep pending till receipt of chemical analysis from Detention, Kamruk, my lord. And he also, I have personally prepared a postmortem report. Generally, cerebral hemorrhage can take place due to spontaneous, due to injury, fall from height, due to assault and road traffic accident. And as per my lord FIR lost by the victim brother, my lord, he stated that at that at that time of lodging the Azahar, I only mentioned the name of the Sri Ranjit Kolita and other as because I only saw Sri Ranjit Kolita at the house of the Sri Satisar. I have not mentioned in the Azahar about Ranjit Kolita being caught and brought there by people. It is a fact that I did not state before the police about the accused Ranjit Kolita belongs caught and brought by the people to that place. On the day of incident that I had proceeded to the place of occurrence, I did not rest there. I went to the house of teacher Sotis on seeing gathering there. It is a fact that I not state before the police that Ranjit Kolita had told before me about the involvement of Biswajit Das and Prolekya Kolita. I do not remember whether
Now you want to say that on the basis of only two witnesses,
only
the
two
order of
witnesses-
conviction was passed.
conviction. They are
The rest of the witnesses did not support.
Witness is omission, my omission.
No,
my lord.
witness is omission, I don't know. But the question is that are the rest of the witnesses,
They
they did
not involved in this case.
No,
Not
no, no. Rest of the witnesses, they have not supported the prosecution case.
Yes, madam.
Huh?
Yes, madam.
How many? 13 witnesses examined?
Yes.
Out of 13? No
And
one
what-
has.
Out of 13, my lord, only two witness, my lord. Indrajit Das and Pankaj Das. They are PW, my lord.
Actually, there should be some specific reason for this, that should be in the, while dealing with this kind of petition.
Chandrajit Das, my lord.
Only
PW
appreciating the evidence is not proper, in
my lord.
fact. It's not the stage of appreciating evidence.
Chandan Deka, my lord, he stated in his evidence, my lord, he stated, I know what the accused person.
Usually, my lord, usually, my lord, when the appeal is, my lord, admitted, my lord, or my lord, LCR, IA is considered, my lord. Basically, my lord, the LCR was called for, my lord, and my lord, LCR is produced. It's a 4 years conviction, my lord. But in this case, my lord, my humble submission is that she is insisting because the other co-accused has been
No,
granted,
but
my lord.
as per my lord, kindly
It is
see,
a-
my lord, page 83, my lord. I witness, my lord, Chandan Deka, who stated that I know what the accused person we are seen in the dock today that we are hauling from neighboring village. I know the informant. The incident took place on 29/4/2015 at last night at about 2 a.m. I was present at the Bihu function. Incident was happened, my lord, at Bihu function. There are 3,000 and 4,000 people are audience are present, my lord. At this stage, the right I was attending the function as volunteer at the gate near the stage. That time, both the accused along with another boy, Prolekya Kolita, were assaulting Tirtha Das by first and low, but they are not detected. The body of the alpha judgment, my lord. I have
Lordship, may
stated
kindly
that
come to my lord, page number 54, my lord, Jasmine, my lord. So
Jasmine-
you hear the picture, my lord. Page number 54 of the memo of approval, my lord, and paragraph 45, my lord, of the judgment. Page number 54 of the memo of appeal, my lord.
54.
54. Page number 54 of the memo of appeal and paragraph number 45, my lord.
54, I don't know.
Appeal to judge
Page number 54.
of the memo of appeal.
Oh, it's a main appeal, sorry, sir. Yes, para?
Para 45, my lord.
that is the 41 page, my lord, page 53.
जो बाबा ने पूरी है।
Yes. What is there?
This is the, my lord, actually, my lord, what the line of trial court has found, my lord. In the same case, we have found that on the date of occurrence during Bihu function, there was an altercation between the accused person and the victim. And thereafter, the accused person took the victim towards backside of the stage and gave him fists and blows, which ultimately caused death of the victim. There was no evidence to show that apart from fists and blows, any other weapon was used to assault the victim. From the testimonials of the PWs, it appears that initially an altercation has taken place, and thereafter the accused person has assaulted the victim with fists and blows. It appears that the assault was not pre-planned, and the accused person assaulted him after the altercation with the victim. From the above, it is clear that intention of the accused person were not to commit murder of the victim. However, due to the assault committed by the accused person, the victim suffered brain hemorrhage and ultimately died. It is a converted to 304.
That's right.
Initially, it was a case of 302, but it was converted to 304 and punishment was malnutrition.
But it was a sudden fighting.
Sudden fighting.
My lord, as kindly see page 27, my lord. Learned counsel Vishwajit Das submitted that though PW as well judgment, my lord, PW 3 and 4 claims themselves by to be the eyewitness and stated they have seen the accused person as well as another assaulting the disease with fist and blow, but have not mentioned on the part of the body assault was made. How can they are seen the eyewitness, my lord? So that is the omission of the witness, my lord. Not a significant Indian, my lord. Omission is
Where you are reading?
they have said I have seen
Where? In which page? 27
27, my lord.
of appeal.
Appeal, my lord.
Ah.
Appeal, that is the as per judgment, my lord. Learned counsel for I think Vishwajit has submitted that though PW 3 and PW 4 claim only for two witnesses submitted their eyewitness, PW 3 and PW 4. They are claimed themselves to be the eyewitness and stated they have seen the accused person as well as another assaulting the deceased with fist and blow, but they have not mentioned on the part of the body assault was made. It is
Where it is not part of the body?
Body. That is not mentioned. That
Where?
fist and blows and they already they have not mentioned the abdomen, head and leg, whose part? They are not identified, my lord. They have already seen that I have seen. That is the contradictory statement, my lord. And on the view function, my lord.
As they omitted or as there is an omission that they have not seen the part of the body where it was diffused
Yes,
and
my
blows
lord,
were
because
that is the
already
reason.
as per my lord PW1, doctor stated that no injury was found in the body, my lord. And the informant also said that he has not seen any injury in the body of the victim, my lord. Only for the brain hemorrhage, my lord. Actual fact is that the victim was dancing in the view function. Subsequently, he was fall down and some other audience, my lord, he took him inside his house, my lord. And we are involved only for the basis of the suspect, my lord. Because we are the present in the view function near the victim, my lord. So we are implicate the case, my lord. That they are not, PW informant also stated that there is no relation along with the victim and accused person, my lord. Previously, before view function, my lord. So there is no intention for murder, my lord. That subsequent evidence, my lord, contradictory and omission, my lord. So my humble prayer, I may be considered and he may allow to go and bail, my lord. Already he is falsely implicated in this case, my lord.
Where the eyewitnesses of the eyewitnesses?
Eyewitness PW 3 and 4, my lord.
Page number?
And Chandrajit.
Page number?
Page number, my lord. PW3, my lord, 83 page number, and PW he is the Sondon Deka, my lord.
83. Page number?
83, my lord. 35 copy, 83, my lord. NXR 3.
What is it?
NXR 3,
82
page
page number?
83.
Where is 82 page number? Page number 83 should say.
Main appeal নহয় তাত তুমি দিয়া আছে যিদিনাখন সাত কৰা আছে মেইন এপিল নহয় মিষ্টেচতে আছে No, tolak, this case of tolak. Repeat to that. Sondon Deka. Yes, Sondon Nolo. I know both the accused person who is seen in the dock today. They are hauling from Lengal village. I know the informant. The incident took place on 29/4/2015 at last night at about 2 a.m. I was present at the Bihu function near the state. Right, I was attending the function as a volunteer at the space near the at the gate near the space. That time, both the accused along with another boy, Prolecto Colita, were assaulting Tirthodas by fish and blow method. No weapon there, my lord. Only for fish and blow, and they are not stated that which part of the body they are attacked. And that time it was, he also stated in cross-examination, and that time it was raining, and while I was witnesses the incident, I tried to go near the dam to intervene, but the accused person, after seeing me proceeding there, left the escape. I could identify them when accused person fled away from there. I seized them to the certain extent, but I could not apprehend them. Subsequently, he stated that, my lord, when I returned back to the east spot of the incident and I could not find Tirthodas, there was by the time was taken to the house of one Satish Das in the unconscious state. After the incident, I, along with few boys of our village, go home to the accused Ranjit and the other accused flew away from there. But he is not stated that we are running on condition and of the Ranjit. Subsequently, that statement is not stated before the police, my lord. We brought the accused to those house of the Satish. There was a brother of Tirthodas who was present. CRPF personnel were also present along with police, and we.
Which one you are reading? PW4. PW4.
Also, he stated that PW3, my lord. PW3, page 83 and 84. That here, in cross-examination, he stated that there were around 3,000, 4,000 people in the Bihu function. In cross-examination, he stated, my lord, there were around 3,000, 4,000 people in the Bihu function. There was no sufficient sitting capacity. He also stated there is no sufficient sitting capacity in the Bihu function. At the time of function, some of the audience were dancing. He admitted, my lord, that some audience were dancing. And real fact is that victim is also dancing in the Bihu function, and he found out subsequently he was taken to Satish Das' house, my lord. Accused petitioner is not involved in this case, my lord. Only his fault is that he see the Bihu function near the victim, my lord. That is their fault, my lord. At that time of the function, some audience were dancing. I have not seen the Tirthodas dancing in the Bihu function. Some audience dancing, but he is not seen who was done this, my lord. It is not a fact that the Tirthodas were dancing in that place. Pendant fall down. It is not a fact that while the deceased Tirthodas fall down, I only saw this. I was not seen any other person interfering the quarrel when I proceeded near the victim. That is also the contradictory statement, my lord. Subsequently, he said that I have not noticed whether some other out of 4,000 people in the audience have seen the occurrence or not. That is also contradictory, my lord. I reached the place of occurrence just within 2 minutes. I have not noticed whether any other person come to the place of occurrence when I arrived there. It is not a fact that I have not identified the accused person under the light, as a light were not sufficient. Views function, my lord, that light is not sufficient for identify some distance, my lord. It is a night period, my lord, not a day, my lord. So subsequently, it is not a fact that I found the accused, I could not identify them.
But it is not a fact.
Not a
He is
fact.
never, nowhere it is.
It is
See, he is nowhere stated that he could not identify. Everywhere he is saying that he could identify. It's not a fact.
Stated, my lord, is around 3,000 to 4,000.
Obviously, 3,000, 4,000 people gathered in the, but he's consistently saying that he could identify them. They were there and he saw them.
No, my lord, he stated that when I went to the.
No, my lord, no, he said here only.
Here is statement, my lord, but that is the omission of the statement, my lord. Marital false, Marital. That is the false, my lord.
It's a case of 304, my lord. That is the.
That's why trial court had been told that it is not a case of murder. So it had turned to 304.
Maybe intention mens rea may not be there.
May not be there, may not be there. That is the reason why it is.
And also he stated, man, I cannot say whether.
No, entire evidence we cannot appreciate at this time.
That's this, my lord. I cannot say whether anybody behind me was where then I was seizing the accused. I cannot say the name of the other boy.
Now see, there was a quarrel.
Quarrel.
3,000-4,000 people were there in a view function. At a moment when he was, they were hitting him with fist and blows. He saw, he came, they tried to come near the victim. And at that moment, they fled away and he chased them. So at that time, while chasing them, he may not be aware who was there in behind him. That may not be there.
Where sitting capacity is not available, my lord, some gathering is
That's
there.
why, that's why sitting,
From this place of occurrence, my lord.
sitting capacity was not available. Lots of people were
Lots
there.
of
That's why the
dance-
incident had happened. Also, when some quarrel took place and then
Some
it had happened.
cases are stated, my lord, the incident.
Yes, what
was
is your
happened.
submission?
I leave it to your lordship, my lord, because my lord, from the trial court, my lord, observation, my lord, the mens rea was not there, my lord. It was not intention to, my lord, kill him. But my lord, there was
Obviously.
a scuffle, my lord. They gave him his blow, my lord, and ultimately he sustained some injury. He died, my lord.
As far
It's
as
not there. There are some I mean, that is vital contradictions are there. That is not the issue. The issue is that there was no.
Matter will be, my lord, finally heard, my lord. If she is, my lord, starting hitting one after another evidence, my lord, the entire matter should have to be heard.
my lord, kindly better, I may be considered, yeah, after, before the record call, my lord, I may be considered, my lord. Already
Record is
co-accused,
not yet received.
Record not received.
already co-accused, my lord, release on bail, my lord.
I have heard. You have
Same
mentioned this word, I think not more less than 50 times.
accused, my lord, same case, my lord, same incident. So my humble prayer is.
See the order of the coordinate bench. There is no mention at all, in fact.
14/11/2024 is the date. The next are 4, my lord, page 117, my lord. Bail order, my lord. Compound order. Bail, my lord.
One thing, so
One.
one. There are two accused person, my lord.
Two accused
There are two
person.
accused person, my lord. One already granted, my lord. Yes, separate.
Bail, my lord. On 14/11/2024, my lord.
Yeah.
Oh, jail. Oh, he's already jail.
In the trial stage where he was an entire trial, he was in bail.
Yes, my lord.
Huh?
Yes, my lord.
So since when he is in custody?
Okay.
Date of judgment.
Judgment, my
Date
lord.
of judgment is
5/11/2024, my lord.
5/11.
Yes, my lord.
Judgment is of 5/11.
5/11, my lord.
5/11. Case number 21. my lord.
Considering the fact that there may not be point of absconding because it was a case not under section 302, subsequently 304 part 2, as you have submitted. There's an observation by the learned trial court below also. All of a sudden fight, there was a took place. Find that it's maybe allowed to go on.
Highly applicable. Loss of liberty.
That means the last.
Appeal already admitted. Already admitted. LCR to Ahipana, LCR to Ahibudi.
Item number
Let
47.
both the appeal maybe my lord take together, my lord.
Yes, other appeal number, what is the other appeal
Yes, my
number?
lord. Case number.
Tell us.
My lord, criminal appeal number
382/24, my lord.
Criminal appeal number 382.
382/24.
We take together.
Item number 47, my lord. My client is in jail for more than 1 year, my lord. So, my lord, a date may be fixed only.
No, it will be month of January only, no date.
In the month of January, my lord.
My lord,
A date may be given at least.
my lord, in item number 39, I may be permitted to take next steps to the informant victim, but the only problem is that the earlier step has come back without any service. So I may be permitted to take fresh steps through the officer in charge of the concerned police station. The officer in charge of Govardhana Police Station. In item number 39, my lord. The first earlier the steps was taken, but it has not come back. Neither the ID card, no service report. So I would like to take fresh steps upon the informant victim. However, through the officer in charge of the concerned police station.
Officer on the Chinchas police station. The earlier, it has already been returned unserved.
Yes, ma'am.
But without?
AD has not, no. It has not come back unserved. AD did not come back. Even the postal consignment did not come back. So it has got lost.
Still awaited.
Now, there is an office note from the Wazima court that it has not come back. So I've been directed to take fresh steps. Now
Earlier only you have directed.
Yes, by the Lojima court to take fresh steps. That is an order of the Lojima court on 26/7 to take fresh steps. The problem is if I take fresh steps up in the same process, then it may again get lost. So if this honorable court permits me to take steps for service of notice upon the victim girl through the officer in charge of the concerned police station where the case was registered, then my lord, it will expedite the whole thing, my lord.
Mr. Mohammed is submitted by him that as he, you know. But Lozima court has received a report, not yet received.
Hey, Lojima report to dekha jo.
No, I'm not in a position to take that.
No, Lojima has given a report that ADCAT has not come back. Even the notice, unserved notice has also not come. So I should take fresh steps.
As per the report of the Lozima court, neither the ADCAT nor the unserved notice is returned back to the Lozima court, and accordingly, it was directed by the Lozima court to take fresh steps. However, Mr. Daspota is submitted that
No, I'm Mr. S.
he
Chakraborty.
may be allowed to take fresh steps through OC of the concern, OC of the district police station. They are allowed.
Govardhana police station.
Fresh step may be taken within a week.
OC Govardhana police station. OC Govardhana police station.
But responding, they will separate. Okay.
That's only.
Okay.